Start now.
Good morning, one and all, virtually present here to this national conference on international taxation. So, after 2 days of knowledge fest on international taxation on various issues, today we came to the end of the third day of this international taxation conference. We have with us CA Karthik Mehta from Mumbai to share his views on withholding taxes on payments to non-residents under Section 195, 196 A, B, C, D, and including the Form 15CA and 15CB compliances, which is very much needed because we are all facing the practical difficulties in compliance in this regard. So without much ado, on behalf of SIRC of ICAI and International Taxation Committee of ICAI, I wholeheartedly welcome our today's opening batsman of session, Sri Karthik Mehta. Before handing over the session, I would like to briefly introduce our session speaker. Karthik is a fellow chartered accountant and has been trusted advisor to businesses over a decade and has garnered extensive experience dealing in domestic taxes, transfer pricing, foreign exchange relations, as well as international tax arena. He also has an extensive experience in representation and litigation, and his enterprising trade has led him working beside some of the best Indian counsel, including senior counsels and senior tax experts. He has advised businesses on various direct tax aspects, providing assistance in developing tax efficient and complete business structures, inbound and outbound investments from a taxation and regulatory standpoint, cross-border taxation, conducted tax due diligence, prepared transfer pricing policies, and study reports. He plays an active role in various committees of professional associations and has been part of the teams that has made several representations to statutory authorities and regulations. He has also contributed several articles on various complex direct tax laws issues in many tax journals. So with this very brief introduction, now I'm handing over the session to CA Karthik Mehta. So over to you, sir. And once again, we all wholeheartedly welcome you to today's session, sir. Thank you.
Thank you, CA Geeta. And good morning, friends. Before we start today's session, I would like to thank the SIRC and all the committee members and the team members for inviting me today to share my thoughts on this important topic. I'll share my screen now. Is it visible to all?
Yes, sir. Screen is visible. Sir.
Okay. Okay, great. So just a minute. Yeah. Okay. So, friends, good morning again. And today's topic, friends, is a very important topic, a very practical topic. Withholding tax on payments to non-residents has always been a topic where there are several complexities. It's an uncertain area that we deal in this last, especially 1.5 years, because of this pandemic. A lot of Indian businesses are availing services online, and the services that we are availing from non-residents has also been on the rise because of globalization and digitalization, where today physical boundaries, the geographical boundaries, are just there, but businesses are venturing and dealing, across the globe like never before. And especially in this time, the withholding tax for any income that the non-resident is earning in India, the withholding tax element thereon becomes extremely critical for us to understand. So let's understand, friends, let's take a few steps back and understand the fundamental principles of a withholding, right? The scheme of the income tax law is designed as such that any income that a taxpayer earns, the income tax authorities, the government, would like to collect the taxes at the earliest point in time, right? So you pay taxes in the form of TDS, tax deduction at source, tax collection at source. And the reason for that is the government authorities want to ensure that the taxes are collected on a concurrent basis as and when the transactions keep on happening. The withholding aspects, the TDS aspects also helps to keep in check any tax evasion. It keeps on bringing regular inflow, cash flow to the government authorities as well, because they also need to function. They have certain administrative expenses. They need to do their spending in line with the finance budget, which has been drawn up by the finance ministry. And as I mentioned, it also helps to keep the tax evasion in check. And let's take an example. Let's compare how the withholding, in terms of a resident scenario and in terms of, when a non-resident is involved, how, the different scenarios pan out. So friends, let's take an example where a resident taxpayer is making payment to another resident recipient. Now we have sections 194C, 194H, 194I, which clearly lay down that there is a certain percentage of withholding which has been given. There are monetary thresholds which have been provided that if the payment or the transaction value increases that certain threshold, you are obligated to withhold tax on the payment or the sum which has been paid, right? It doesn't necessarily refer to the income component. The transactions between two residents, our government has jurisdiction over both of them, right? And that is why the department only wants to know that what sort of transactions are taking place, and it just wants to collect information regarding the payer and the recipient. So it doesn't necessarily even need to have an income component when you are withholding. Now, take this scenario when the recipient is a non-resident, right? At that point in time, what is important for a government, for an exchequer, is that the right and the adequate amount of taxes is collected at source. And this is simply because if, let's say, a resident makes a payment to a non-resident without withholding taxes, or withholding taxes at a lower rate than what it was supposed to, right? And the money has gone out of India. Now our tax authorities will find it extremely difficult in order to track the non-resident recipient and try and collect the right amount of taxes from them. And hence, when it comes to non-resident, it is a sovereign right, as a matter of fact, that the government allows or has provisions under the domestic tax law, whereby the recipient, the non-resident recipient's tax liability is discharged at source itself. Let's say, friends, a non-resident recipient in US, the income has been remitted without withholding any taxes, where tax was actually supposed to be withheld. If our government now tries and to approach the non-resident for recovery of taxes, there are several practical and technical issues because of which our tax authorities may not be able to collect that tax. First of all, there is a huge administrative cost involved on the part of the tax authorities to locate and to trace the taxpayer. Second, and most importantly, is the jurisdiction which our tax authorities have or does not have on that particular non-resident who is, let's say, based in US, UK, Canada, or anywhere across the globe. And that is why withholding provisions under a domestic tax law, not only for India, but for any country, are absolutely imperative. And today, because of this cross-border transactions happening very frequently, all the governments across the globe are emphasizing a lot on these withholding tax provisions. Now, before we move ahead and try to understand, the section 195 and the related nuances, it is important to go and look at some fundamental provisions and understand the scheme of the Income Tax Act. Now, as I mentioned, friends, for a resident, it is not necessary that the remittance or the payment that you are making to them needs to bear an income component. But when it comes to a non-resident, that gains importance, and we'll have a look at it. So friends, section 4 under the Income Tax Act deals with the chargeability of income tax. It states that income which is chargeable to tax has to be deducted at source or has to be paid in advance. Friends, if you would observe the scheme of the Income Tax Act, the department seeks to cover tax on a concurrent basis from the income earner. So your tax gets deposited with the government in the form of sorry, a tax deduction at source, a tax collection at source. Then you are also obligated to discharge your tax liability by way of an advance tax payment. And only at the end, if there is a shortfall in your entire tax payment, you make a self-assessment, tax payment to the government, to the tax authorities as well, right? So the idea is to collect the tax at the earliest point in time, be it by way of a deduction or by way of an advance tax. Now moving on to section 5, it deals with the scope of the income which is chargeable to tax in India under the Indian Income Tax Act. Now section 5(1) deals with the scope of income for a resident, right? Today, friends, we are not concerned with a resident's scope of income under the tax law. Today we are going to discuss the second limb, which is section 5 subsection 2, which talks about a non-resident's scope of income under the Indian income tax law. So it says for a non-resident's income to be taxable in India, the income needs to be received or deemed to be received in India, or income needs to accrue or arise or deems to accrue or arise in India. Now friends, insofar as received in India or accrued or arising in India, these sort of aspects are fairly straightforward. If you peruse the transaction, if you review the transaction and analyze it thoroughly, you will be able to conclude that yes, whether the income is received or accrue or arises in India or not. The real complication and the challenges arise when you go to the deeming provisions which have been given under 5(2), which is deemed to be received in India or deems to accrue or arise in India. And friends, it is in this context that before we move on to understand section 195(1) or the related withholding nuances, it's important to understand how this deeming fiction works, what all aspects are there that we need to consider, because only when an income is chargeable to tax in India for a non-resident, that is when the need for withholding arises. So chargeability and the scope is a fundamental before we can move on to the withholding element. And for that purpose, friends, understanding and a study of section 9 is absolutely imperative when you are dealing with understanding whether a non-resident's income is deemed to accrue or arise in India or not. Section 9, the entire series, friends, 9(1) to 9(8) has been evolving over a period of time with this new age business models coming into the picture, more and more complex business structures coming into the picture. The government is also evolving section 9 year on year by inserting explanations, provisos, adding new sections, because they also want to keep up with the pace in which how the business transactions are being entered into, and want to ensure that India doesn't lose out on its fair share of taxes when the payments are being made to non-residents. So friends, let's try and understand or have an overview or understand what section 9 contemplates. Section 9(1)(1) deals with a non-resident's business or professional income earned in India through a business connection in India. It also includes a non-resident's income earned through a dependent agent and through a significant economic presence which it would have in India. Similarly, section 9(1) also contemplates that if a non-resident earns any income from a property or an asset located in India, or from a source of income which is also located in India. And finally, section 9(1)(1) also seeks to cover the transfer of a capital asset or an interest in an entity in India, which is deriving its value substantially from the assets located in India. And we'll quickly run through all of these things just to give an idea as to how in different facts and scenarios could the tax implication or could the the income being covered under section 9(1)(1) is there, or the case is otherwise. So let's take an example, friends, where a non-resident exporter is exporting goods into India. So your Indian client is actually importing goods into India. Now, if that non-resident exporter doesn't have any business connection in India, and the Indian importer has met the non-resident exporter in a trade seminar outside of India, or from its global website has placed an order, It's a pure import of goods into India. The non-resident does not have any business connection in India, and because there is no permanent establishment or any sort of a presence in India on account of the non-resident, such payments may not be chargeable to tax in India. Right now, if you twist this fact pattern a little bit, where your Indian resident company is wanting to, let's say, buy a large equipment from a non-resident equipment manufacturer, and for that purpose the non-resident sends a delegation of their team members who, let's say, for a short period of time needs to stay in India. They do the site visit, they do the feasibility study, they take the measurements of of the premises, then they sit in India, do a technical discussion, then the contract is negotiated in India, the commercials and the terms and conditions are finalized in India, finally the agreement is also executed in India, and after that this delegation goes back to their home country, and then the equipment is actually imported into India after it is manufactured, and the Indian company makes a payment for that. Now in this scenario, friends, because the non-resident has carried out certain activities in India, has a business connection in India, it may be a scenario where a part of the entire consideration which the resident has paid, certain portion can be attributed to activities carried out in India, and to that extent there may be an income chargeable to tax in India for a non-resident on which withholding is required, right? Similarly, if let's say a non-resident is carrying out business activities in India through an agent, now again, insofar as an agency is concerned, the statute provides that if it is an agent of an independent nature, then there is not any business connection which the non-resident has in India. But if that agent is a dependent agent, then yes, there may be certain profits which may be attributed to activities carried out in India. And once again, we may have to analyze the transaction thoroughly, understand the nuances, look at the principles laid down by jurisprudence over these years, and take a call on whether any withholding is required or not. Similarly, friends, on account of any other income or any capital gains which a non-resident earns on account of any property or asset or source of income which is located in India, there will be a certain withholding which also needs to be done if such income is deemed to accrue or arise in India under section 911. And then finally, friends, we have our amendment which was carried out pursuant to the Vodafone's decision by the Honorable Supreme Court, wherein it said that even in case of a transfer of a non-resident entity shares by one non-resident to another non-resident, but if that non-resident entity is deriving its value substantially from assets located in India, then such kind of a transfer will also be chargeable to tax in India under the Indian domestic tax law. So in these kind of situations, as we have seen, friends, it's a completely fact-driven exercise. We need to ask questions to the other party. We need to understand the transactions. We need to understand how events have transpired. In case, the earlier part which we discussed, where a non-resident may have a business connection in India. If it's a case of transfer of a non-resident entity, then we need to see that whether its subsidiaries are actually contributing to more than 50% of its value. We need to obtain adequate valuation reports. And once we have all these documents in place, then we can take a call whether income is deemed to accrue or arise in India under section 911 for the non-resident or not. Okay. Likewise, under section 912 and 913, these two subsections deal with the salary income earned by a non-resident from India. Now, friends, strictly speaking, 195 does not deal with the salary provisions. Be it a resident or a non-resident, the salary payments and the withholding thereon continue to be governed by section 192. But even then, for the sake of completeness, we have listed down section 912 over here. So again, very important to understand, if an Indian company's employee has been deputed overseas for a project for a short period of time, likewise, if a non-resident's employee has been deputed to India for let's say a short period of time of 3 to 6 months, then depending upon the tenure, the residential status of that particular individual, if it is a non-resident, and if the income is set to deemed to accrue or arise in India in line with section 912 or 913, there may be a withholding requirement under section 192. Moving on to section 914. Moving on to section 914, where dividend is paid by an Indian company to its non-resident shareholder. So friends, we all know until a couple of years back, dividend was exempt in the hands of the recipient shareholders. Dividend distribution tax was paid by the company in its own hands. Now, the taxability of the dividend has shifted from the company to the recipient shareholder. And that's why now the withholding aspect is becoming very important, very critical. So let's take an example where you have two shareholders of an Indian company. One shareholder is a resident and the other shareholder is a non-resident. Now, insofar as a resident shareholder is concerned, if a dividend is being declared and subject to the monetary threshold provided under the domestic tax law, you will withhold 10% on the dividend payment and you will make the balance 90% payment to the recipient shareholder who is a resident. Now, when you come to the non-resident shareholder, it becomes important to understand a lot of other factors as well, which we'll see in the later part of the presentation. One of them being whether the dividend recipient shareholder is a beneficial owner or not. But subject to all those factors, the domestic tax law provides that the non-resident's dividend income, the tax which needs to be withheld at source is 20% plus surcharge and cess, which is given under section 115 capital A. Now, friends, at this point in time, as we all know, India has entered into double tax avoidance agreement with several countries. More than 90 treaties have been entered into by India. And as we saw in in business income under section 911, salary income under section 912, and now under for dividend, if India has entered into a double tax avoidance agreement with the country in which the non-resident recipient shareholder is located, then it becomes important for us to even evaluate the implications under the DTAA. So just for the benefit of all, DTAA, friends, has several articles. It's a bilateral agreement entered into between two countries. As I mentioned, India has entered into 90 plus of such bilateral agreements. There are several articles which lay down the tax implications or the taxability of the different sources of income, different streams of income under the respective articles. There are also articles pertaining to mutual agreement procedures, FTCs, and other aspects that the two countries would have negotiated between them, and that's why they form part of this bilateral agreement. So whenever an Indian company is making actually a payment to a non-resident, along with the domestic tax law, we also need to evaluate the implications that may arise under the domestic tax avoidance agreement which India may have entered into. Now, if let's say under the domestic tax law we come to a conclusion that a particular income is not chargeable to tax in India, then we may not have to go to a DTAA, because then that would just merely become an academic exercise. But if let's say an income is chargeable to tax under the domestic tax law, then we need to go to the DTAA and subject to certain documents being provided by the non-resident, basis which the non-resident will be eligible to obtain benefits under the DTAA. If the DTAA provisions are beneficial to the non-resident, then the non-resident will want to take recourse under the under the double tax avoidance agreement and seek to tax its income at a beneficial or a lower rate. So at every point in time, whenever we are making payment to a non-resident, friends, analysis and evaluation under the domestic tax law as well as under the DTAA is imperative. Now, insofar as dividend is concerned, most of the treaties that that India has entered into has the concept of a beneficial ownership insofar as the recipient of the dividend is concerned, and only if the recipient is actually a beneficial owner, there is generally a concessional rate being provided. It could range from 5, 10 or up to even 15%. And because that is beneficial for a non-resident recipient, the non-resident would generally want to get itself covered under the DTAA. Now friends, moving on to section 916, payments made to non-residents on account of royalty. And 917 deals with payments made to non-residents on account of fees for technical services. Both these payments characterized under royalty as well as FTS has been a subject matter of litigation for over past many years. Royalty, friends, the definition under the domestic tax law is very wide. Okay, especially after the insertion of explanation 4 to explanation 6, which was also introduced by way of a retrospective amendment. Almost everything covered under the sun can be termed as royalty insofar as a payment is made by a resident to a non-resident, right? And that is why most of the payments that typically your clients would be making for accessing any software, any database from a non-resident, under the domestic tax law, it is likely that the payment would be construed as royalty. And that's where once again we need to jump to the DTAA to evaluate and analyze whether the payment that is being made by the resident to the non-resident would classify as royalty as well under the DTAA or not. And friends, it is very interesting because that's a bilateral agreement, right? Whilst India has unilaterally amended the domestic tax law and inserted explanation 4, 5 and 6 to section 916, the definition of the term royalty under the domestic tax law continues to be restrictive, continues to be narrow. And that's why more often than not, insofar as payments under the head royalty is concerned, mostly you would have to seek recourse under the DTAA to make a claim that this amount is not chargeable to tax in India in the hands of the non-resident, and hence there is no need to withhold any taxes in India. Just in terms of the rate which has been given under the domestic tax law, the rate is 10%. This of course needs to be increased by surcharge and cess. Insofar as the DTAA is concerned, generally the rate is provided at 15%. However, some treaties do provide for an alternative concessional rate, but that's merely on a piecemeal basis. But generally the rate is 15%. So friends, if let's say you do analyze a transaction for your client and you come to a conclusion that yes, the payment which I'm making to the non-resident is royalty under the domestic tax law, as well as it is royalty under the DTAA, then it may actually make sense to get covered under the domestic tax law itself, because the tax rate under the domestic tax law is beneficial to the non-resident, because it is 10% plus surcharge and cess, which will come likely to around 12% vis-a-vis the absolute tax rate of 15% under the DTAA. Now, friends, I have put this important decision which was rendered last year by the Honorable Supreme Court in the case of Engineering Analysis Center. As I mentioned, the payments construed as royalty and whether they are chargeable to tax in India or not has been a subject matter of litigation for over last maybe 15 years or so. We had conflicting decisions, contrary decisions by high courts across the country. Karnataka High Court had decided against, Delhi High Court was in favor, and the matter then finally reached up to the Supreme Court in a batch of appeals. Okay, and the lead matter Supreme Court decided it to be engineering analysis, and the Supreme Court has given its opinion that purchase of software by a resident end user from the foreign supplier manufacturer directly, such payments will not be construed to be royalty. Similarly, they have said that payments for software by resident distributor or reseller from the foreign supplier manufacturer will also be not to be construed as royalty. Then purchase of software by the Indian distributor, reseller or end user from a non-resident distributor or seller will not be construed as a royalty. And finally, software bundled with hardware sold by the foreign supplier to the Indian distributor or the end users will not be construed as royalty. Friends, this is a 200 plus pages decision. I would urge all of you to go ahead and read it. I have summarized it over here, just the important points that have been rendered by the Honorable Supreme Court in this decision. they very exclusively laid down that insofar as the payments which is being made is not for the transfer of the copyright, but it is for a right in or a use of copyright. And then they have in very depth discussed what is copyright under the Copyright Act, its definition, the related nuances, and under this arrangement, which typically an Indian businesses would get from your non-resident IP provider for which the payment is being made, what is actually being given to the resident for use. The resident does not have a right to transfer, does not have a right to copy the IP. The resident merely gets a right to use a licensed product for its own benefit. It doesn't even have a right to resell, right? So all these discussions have been done in this Supreme Court decision. Please friends, do read it. The relevant portions of this may also be quoted in the opinion or the note that we give to our clients as a supporting, when they approach us for their advice, for our advice on whether the payments being made to the non-resident construes royalty or not. A couple of other points also which Supreme Court has touched upon is one contention which was raised before the Supreme Court was that the assessee failed to withhold taxes. And again, this principle is important on a standalone basis as well, friends. Much like the Vodafone decision, the Supreme Court once again has reiterated that when the statute introduces a retrospective amendment, right? So the year in which the transaction takes place, there was no provision under the law. There was no explanation 4, 5, and 6 under the under section 916. And just because White Finance Act 2012, if the statute introduces explanation 4, 5, 6 with retrospective effect for any year prior to that, when the payment was actually made by the resident to the non-resident, the resident remitter cannot be expected to withhold taxes when there was no provision in place. So the impossibility of performance principle was once again reiterated by the Supreme Court. And friends, whenever we face similar situations under different sections, please do keep this principle in mind. It is helpful. We have a couple of Supreme Court decisions now to support that contention. The Supreme Court bench also went on to opine, which is again a well-established principle, that DTAA provisions, insofar as they are beneficial to the taxpayer, will be applicable or will override the domestic tax law provisions. And this once again was relevant because, as I mentioned, the definition of the term software under the DTAA is far restrictive than what is the definition of the term royalty under the domestic tax law. So the non-resident, if they want to take shelter under the DTAA, and because those provisions are beneficial, DTAA provisions will override the income tax provisions. And finally, one last point was that the software product or the licensed product, which if it is resold, which if it is sold in a physical object, right, it amounts to a sale of goods. It doesn't amount to, the payment does not amount to a royalty. Right. Moving on, friends, under section 917, as we discussed, fees for technical services. So what does FTS mean? Is consideration for rendering any managerial, technical, or consulting services. Again, FTS payments for FTS has been a subject matter of litigation, which has been fairly settled by few Supreme Court decisions, especially one in the case of Kotak Securities. Under the domestic tax law, once again, fairly any payment that you make for a technical service is likely to get covered by the definition of the term FTS. But once again, here you can take recourse under the DTAA. Fees for technical services is generally either covered with royalty under Article 12, or there will be a separate article for that. Most of the treaties, friends, may not have a separate article on FTS, in which case you may have to actually go to the other income article, because the non-resident is certainly receiving something from the resident Indian taxpayer. So if there is no dedicated FTS article, then you may have to resort to the other income article. Or finally, you may have to go to the business income article, which is Article 7, and then you will have to evaluate whether that payment gets covered within those relevant provisions or not. Friends, many of the treaties which India has entered into, especially with countries like Singapore, US, UK, Canada, have a concept of make available under the DTAA. And what does make available mean? Is that if the non-resident, during the course of providing its service to the resident, has made available any technical know-how, skills, processes, knowledge to the resident, such that going forward, if the resident wanted to carry out that work on its own, if it is able to carry out the work on its own because of the transfer of the technical knowledge, skill, know-how being made available by the non-resident, then yes, there is a make available, and the payment being made by the resident to the non-resident will get construed as a FTS even under the DTAA. Okay, so where there is only a technical knowledge being used to provide services, but not a transfer of technical knowledge, know-how, skill, it is a good case to be made that there is no make available for technical knowledge, know-how, skill, and that's why the payment being made by the resident to the non-resident will not be construed as FTS under the DTAA. Again, friends, this make available has been up for debate, and there has been a lot of contention. Please understand this concept very well, because just because the person providing services has used certain technical knowledge doesn't mean that he has made available the technical knowledge to the resident. The intention is that, or the genesis is that the resident should be able to perform the services or should be able to carry out the that work on its own in future. Then yes, there is certainly a make available. So a very simple example which I always give to my colleagues to understand this concept absolutely clearly is that, let's say in our offices we all have air conditioners and other IT equipments. If let's say one of the let's say the air conditioner breaks down and we need to get it repaired, now we call a repairman who will come, who will perform his services, repair the air conditioner, and he goes back and we make a payment to him. Now he has certainly used his technical knowledge to repair the air conditioner, but has not transferred the knowledge to us. So going in future, if let's say the air conditioner would have to be breaks down again, we would have to either consult the same repairman or another repairman who is equipped to come and repair the air conditioner, and he would come again and repair the AC, and we'll make a payment to them. It's a very simple example to understand that there is a provision of technical service, but not a make available of technical knowledge, skills, and know-how. Right. So I hope this concept is well understood by everyone, because most of the times when you are making payment to non-residents under FTS, and generally the payments are being made to people from countries like US, UK, Singapore, Canada, more often than not, you will have to take recourse, take shelter under the make available, so that the non-resident's income is not chargeable to tax in India, and hence consequently there will not be any need for withholding. And why I make this point is, friends, because most of these non-residents are fairly large corporate houses which are operating across the globe, right? And they would generally come back and say that if there are any withholding taxes in India, they would be on the Indian remitters account. So they want their net money, and we'll see the grossing up concept as well in the later half of the presentation. But why I'm emphasizing on this point is that many a times the withholding tax component is actually a cost to be borne by the Indian remitter, and that's why it becomes important for us to evaluate and analyze thoroughly, because that is ultimately a cost saving for our Indian clients directly. Just to come in terms of the withholding tax rate, if let's say we conclude that it is an FTS under the domestic tax law, the withholding tax rate is 10%, which is to be increased by surcharge and cess. Under the treaty, once again, if we conclude that it is FTS, the rate is generally 15%. Some treaties do provide for an alternative rate, but once again, if it is an FTS under both the domestic tax law and the treaty, it would be prudent to go under the domestic tax law, because the effective tax rate is slightly or marginally lower than the treaty rate, which is generally 15%. Right, friends, with all this backdrop of understanding a non-resident's income, which may be deemed to accrue or arise in India under Section 9, and now having evaluated and understood the different nuances related to the scope of income, we now move on to Section 195, which deals with the withholding element which is there on the non-resident's income, which is chargeable to tax. So Section 195(1), very important for us to understand this word by word. I've highlighted certain relevant wordings under the section. So let's read it together, friends, for everyone's interest. 195(1) reads, any person responsible for paying to a non-resident, not being a company, or to a foreign company, any interest or section 194 LD or any other sum chargeable under the provisions of this act, not being salary, shall at the time of credit of such income to the account of the payee, or at the time of payment thereof in cash or by issue of a check or draft or any other mode, whichever is earlier, deduct income tax thereon at rates in force. Right, so let's look at the different aspects. 195(1) deals and covers any person responsible for paying. Right, so any person, may be a corporate, maybe a non-corporate, maybe a resident, maybe a non-resident, any person responsible for paying to a non-resident. Okay, it also includes a foreign company. It says the streams of income as any interest or any other sum chargeable under the provisions of this act. So any interest is fairly simple to understand, but any other sum chargeable under the provisions of the act, that is where the entire complexity arises, and hence a need to understand the section 4, 5 and 9 absolutely thoroughly. Right, so any remittance which bears an income component will actually be subjected to tax in India in the hands of the non-resident if it is covered by virtue of section 459, and there will be a need for withholding. Not being income chargeable under the head salary. So as we discussed in the earlier part of the presentation, the term salaries or income arising under salary still continues to be governed by section 192. Now it says the time of credit of such income to the account of the payee or payment thereof in cash. So what the statute is trying to say is that for the first time when you pass an entry in your books, either you are acknowledging your debt to make a payment to the non-resident, or you are making an advance payment to the non-resident. The government wants to collect the tax on that particular remittance, of course bearing an income component at the earliest point in time. Then it says payment thereof in cash or by any other mode. So again, very important to understand that not only an actual physical cash transfer or a fund transfer is covered, even if the payment is made by way of a payment in kind, even then the provisions of section 195(1) get triggered. And finally, the obligation to deduct income tax is at the rates in force. Now this term rates in force has been defined under section 237 capital A. So friends, rates or rates in force, which has been defined under section 237 capital A, it has three subsections. Section 1 and 2 is subsection 1 and 2 is not what we are dealing with today. They essentially deal with the tax deduction and the advance tax payments under different scenarios. Today we are concerned with 237A subsection 3, which says that the rates in force for section 195 would essentially mean that you need to go and fetch the tax rate provided in the Finance Act of that relevant financial year, relevant assessment year, or you take recourse to the rates provided under the DTAA. It is one of these two rates that needs to be ascertained, needs to be determined, and then the withholding needs to happen at that particular rate. Okay, let's look at the proviso which has been given to section 195(1). It says that in the case of interest payable by the government or a public sector bank or a public financial institution deduction of tax shall be made only at the time of payment thereof in cash, right, or by check or any other mode. So there is a relaxation which has been given to government or a public sector bank or a public financial institution. They don't need to withhold tax at the time of passing an entry in their books. They just need to make a deduction at the time of payment. So that's a relaxation given to them. Now moving on to explanation 1. Explanation 1, friends, it says that even if a suspense entry has been created or you just acknowledge a debt in your books, right, you may say that I'm still not sure whether the entire amount is payable, or right now I'm just booking a partial sum, but I don't know my actual liability, what I need to make a payment to the non-resident, and that's why I would not want to withhold taxes. But explanation 1 very clearly says that even if you pass a payable entry or a suspense entry, even then there is an obligation on the part of the resident remitter or on the resident taxpayer to withhold tax at that point in time, because the explanation deems it to be the credit of an income to the non-resident, right? And explanation 2, friends, it's a clarificatory explanation. It was introduced pursuant to the retrospective amendment brought in the statute to counter or overcome the Vodafone's decision by the Supreme Court, and they have introduced this once again as a clarificatory explanation, as a removal of doubts. It is hereby clarified that obligation to comply with subsection 1, that is withhold taxes and to make deduction thereunder, applies and shall be deemed to have always applied, and extends and shall be deemed to have always extended to all person, resident or non-resident. So here once again, because let's say under section 911, as we discussed, if a non-resident entity is deriving its value substantially from India, and that's why by virtue of 911 that income is chargeable to tax in India, if the non-resident is not covered as a person who is supposed to be or who is obligated to withhold tax under 195(1), then the machinery provisions may fail. And that is why explanation 2 has made it abundantly clear that it was always our intention that, be it resident or a non-resident, the person is obligated to deduct taxes if the payment is being made to a non-resident which bears an income component or an income embedded therein, right? So with this, friends, I have written down the scope and applicability. Let's quickly just go through it. So as we discussed, any person responsible for making the payment, the payer or the deductor, irrespective of the legal character or its residential status. Payer also includes non-residents. This has been clarified under explanation 2. We discussed the rationale for having its introduction in the statute, that was to counter the Vodafone's Supreme Court decision. The deductee is any non-resident, and it also includes a foreign company. It also includes a foreign company which is a POEM in India. So the place of effective management provisions, friends, it deems that a person will be considered to be a resident in India for for income tax purposes under section 6 subsection 3. But here, prior to this notification which had come, there were certain doubts as to if, let's say, a non-resident which has a POEM in India gets treated as a resident by virtue of section 6 subsection 3, then whether we need to apply 195 provisions, or whether do we need to withhold under the domestic tax law provisions itself. And that's where this notification 29 of 2018 issued by the CBDT becomes handy. The notification very clearly says that where a foreign company is being paid some amount, but that foreign company has a POEM in India, as long, even if you make compliant, even if you withhold taxes in line with 195(1), that will be a sufficient compliance, because the rationale once again, friends, over here is that ultimately the non-resident is situated outside of India. The government would still want to collect taxes at source at the earliest point in time, bereft of the fact that it has a POEM in India, right? So once again, the accessibility to the taxpayer, the jurisdiction over the taxpayer is something which our government is cognizant of, and that's why the notification just kind of confirms that the tax is supposed to be withheld under section 195(1) or in line with section 195(1) only. The 195(1) section excludes very specifically resident but not ordinarily resident individuals. And friend, here I just want to raise a thought-provoking question. We all know that a couple of years back, Section 6(1) capital A was introduced under the domestic tax law. The section essentially states that where an Indian citizen who is a non-resident, as whose residential status under the Indian domestic tax law for that year is that of a non-resident, but who is also a non-resident everywhere across the globe, which means this individual has not spent enough time anywhere in the world in a particular country, by virtue of which that resident may be classified to be a resident of a particular country other than India. Then Section 6(1)(a) deems such person to be resident in India, and the tax implications will follow accordingly. But the question which I want to raise over here or pose for everyone's thought is that if, let's say, a payment is being made to this kind of an individual, then what is the remitter's obligations in that scenario? Do we treat that person as a resident in India, or do we treat that person as a non-resident? And one more point to evaluate or discuss over here is that because that person is a non-resident across the globe in any other country as well, there will not be any country where he is a resident, and hence which DTAA or under which DTAA should, can I give him the benefit of any concessional withholding tax provisions? So these are just some few questions. It will be interesting to see how this proposition evolves. If such a payment is being made to these kind of individuals, what kind of implications will follow? Currently, there is no clarification on this, from the tax authorities, from the CBDT, but an interesting proposition nonetheless, which we'll see evolve over the next few years. Finally, what is covered under Section 195(1)? When we discuss this, any interest other than those which are covered under the section specified, like 194 LB, LC, LD, or any other sum which is chargeable to tax in India. This, as we discussed, salary income is not included. Friends, one very important point over here is that there are no thresholds prescribed under Section 195(1). So even a nominal amount of payment being made to a non-resident, the same level of analysis and evaluation will be required at our end, insofar as ascertaining whether the non-resident's income is chargeable to tax in India or not, and whether any withholding is required or not. Unlike the domestic tax law, where most of the time there are certain thresholds given under the TDS provisions. When it is to be deducted, so it is to be deducted at the time of payment or credit, whichever is earlier. Relaxation has been given in the proviso, which we have discussed. And finally, once again, the rate of deduction is in line with the rates or rates in force as defined under 237 capital A. It has to be the beneficial rate, which is beneficial either of the rate specified in the Finance Act or the rate prescribed under the DTAA. And friends, as we move ahead, we'll also see that if the non-resident doesn't have a PAN in India, then under 206AA, a higher rate of 20% withholding can also apply. But this section has now been diluted to an extent by virtue of Rule 37 BC, which has been introduced. So once the non-resident provides the information which has been listed down under Rule 37 BC, if the non-resident provides this information to the resident remitter, then the provisions of 206AA would not apply. We'll also have a look at this in detail as we go ahead. Now, friends, two very important decisions rendered in the context of 195(1) and how to interpret or construe the term any sum chargeable to tax. Because as we discussed, the withholding obligation is not on the remittance amount. It is on the income component embedded in the sum which is being remitted. And that is why the section uses the word any sum chargeable to tax. Now, this decision of Transmission Corporation rendered almost 2 decades back, the Supreme Court decided in favor of the assessee. The contention before the Honorable Supreme Court was that whether withholding tax under 195 is to apply only in respect of sums comprising of pure income, and not the gross income, which would include cost or expenses as well. So as we discussed, yes, that is the principle which has evolved over a period of time. But of course, back in 1999, the law was still evolving, so to say, and the Supreme Court has opined that TDS is applicable, or withholding is applicable, not only on the amount, not on the gross consideration, but on the income component embedded therein. Withholding has to be limited to the portion of the income which is chargeable to tax. There is a remedy which is available to the remitter as well as the payee under section 195(2), 195(3), and 197, and they can take recourse to that as and when required. We'll see these sections in detail as we move ahead, friends. And by this decision, it was fairly clear that the income which is chargeable to tax in India, the withholding should happen only on that. However, the department paraphrased certain observations because of the language which was used in the Supreme Court's decision, and once again started taking a view that Basis Transmission Corporation, because of the language used therein, any remittance which is being made to a non-resident is subjected to tax in India. And that's where, in this batch of appeals which finally got decided, where the lead matter was GE India Technology in 2010 by Supreme Court in its another decision, the Karnataka High Court in GE India's technology case had actually decided against the assessee, and it had said that whenever there is a remittance to the non-resident, right, the remitter is either supposed to withhold on the entire amount, or if it is of the view that no, there is no need for withholding, it has to obtain a nil withholding certificate from the tax authorities, and only then the remittance can be made without any withholding. And the matter again went before the Supreme Court. The Supreme Court now has very categorically laid down that if the payer is also fairly certain and he can make his own determination, own assertion regarding what is the income component embedded in the consideration amount, then the remitter can withhold tax only on that component. There is no need for the remitter to approach the AO, the officer under section 195(2), or the payee to approach the officer under section 195(3), and which has been also laid down in a circular 728. So the Supreme Court drew reference to that particular circular as well. So friends, here let's take a couple of practical instances why this decision of GE India Technology becomes very important for us as professionals in our day-to-day advisory practice or compliance practice while serving our clients. Let's take an example where your Indian resident client is acquiring a property but which is held by a non-resident. Okay, so your client is acquiring a residential house, but that is being owned by a non-resident. Now, the commercial consideration will of course be discussed between the two parties. Now, at the time of making the payment to the non-resident, the resident will of course want to withhold tax on the entire amount, because there are onerous responsibilities attached on account of a short deduction or a non-deduction in the form of interest, penalty, and proceedings under 2011A, and finally being regarded as an agent of the non-resident in the representative assessee capacity. However, on the other hand, the non-resident is going to make a claim to the resident to say that, look, here is a consideration, here is my purchase cost of this property when I had actually bought it, right? So this was the year in which I had bought it. So you please allow me indexation benefit. You please reduce all the costs which I am incurring in connection with the transfer, ascertain the right amount of capital gains tax, and only on the consideration which bears the income component, only on that income element, please withhold taxes and pay the net consideration to me, right? So this is a dichotomy that we as professionals also face on a daily basis. Let's say we are representing the resident acquirer in this particular scenario. Our advice is going to be conservative, friends. We are likely to say that unless we are absolutely certain, unless the non-resident provides all the documents and the information for us to conclusively ascertain the cost, let's not take any risks and withhold the tax on the entire amount. The non-resident will file the tax return in India, claim a refund, but at least by doing this action or this activity, we as resident remitter are safeguarded. If we are, let's say, advising the non-resident in this particular scenario, we are likely to make a very strong claim again to the resident and his consultants to say that look at the principle which has been rendered by GE India Technologies decision. If the remitter is fairly certain and can make his own determination of the income component from the consideration, the Supreme Court has opined that yes, without approaching the AO, the withholding may be done on that income component only. So, Mr. Resident, please tell me what all documents and information you require for you to be fairly certain that this is my cost. And the non-resident would actually end up providing the purchase agreement, at the time when the non-resident had purchased the property. If the non-resident is availing certain services from a broker, from a commission agent, then it would also have to provide those kind of agreements and engagement letters which it has entered into with those agents and the brokers, and then the resident needs to compute the capital gains adequately and then take a call whether it wants to withhold tax on that lower amount, which is only the income component, or take a conservative stand and then withhold on the higher amount and leave it to the non-resident for him to claim a refund. So friends, we are caught in this situation almost on a daily basis. Whichever side you are representing, please ensure that the transaction is being carried out in the interest of both the parties. Guide both the parties in the entire transaction to say that this is what is absolutely imperative. This is what is required to safeguard the interest of both the parties. Ensure that the because at the end of the day, we need to be helpful and we need to enable the transaction to happen rather than stick to a particular clause or a proviso or a requirement, and because of which the transaction may fail. However, of course, our first primary duty or responsibility is to the party to whom we are representing. So ensure you guide them, advise them adequately, so that depending upon their interests or depending upon the risks that they may face, they are safeguarded adequately. Another instance, friend, is a lot of transactions are happening these days in terms of share acquisition, mergers, transfer of shares by let's say a resident to a non-resident or vice versa. There, once again, absolutely imperative to take all the declarations, all the information insofar as the capital gains arising to the non-resident transferor is concerned, and then based on the information available and the indemnities and confirmations available, take a call whether you would want to withhold at that lower amount and give the that benefit to the non-resident, or you would not want to get in any unwarranted risks for your client and deduct at the entire amount. Another decision, friends, which was rendered in 2020 by Supreme Court, and this I've just put it over here to just highlight one important point. So in this decision, it actually doesn't pertain to 195. The payments were made by the assessee to non-residents under section 194 capital E, and 194 capital E very specifically uses the words income referred to in 115BBA and 115BBA and 194E read together. The withholding tax rate is provided at a flat rate of 20%. Okay, there is no reference of rates or rates in force under section 194E. There is no reference to having recourse to the DTAA, and that is why the Supreme Court opined that insofar as this payment under 194E is concerned, the assessee was obligated to withhold at a flat rate of 20%, of course, which will be increased by surcharge and cess. But in absence of reference to 237 capital A, you will not be allowed to or not be permitted to go to the DTAA and take a concessional rate. This ruling was, a lot of debate and a lot of questions were raised around this decision. because ultimately you have section 90 subsection 2 of the income tax law, which very categorically lays down that for a non-resident whose income is chargeable to tax in India, to the extent DTAA provisions are beneficial to him, the domestic tax law provisions would not apply to that extent. And hence, to one's mind, in this decision, in this decision of Pilcom, the aspect of 90 subsection 2 not being considered, is certainly there, and that's why it becomes important for us also to distinguish this decision if it is relied upon by the income tax authorities, during the course of any assessment proceedings that we are helping our client with, or when you are advising your client in terms of making a payment to the non-resident. Just drawing back, the reference to the engineering analysis decision, there the Supreme Court has also referred to the Pilcom's decision, and in a certain way distinguished, and the rationale given is exactly this, that 90 subsection 2 says that to the extent DTAA provisions are beneficial to the non-resident, they will apply and override the domestic tax law provisions to that extent. And that is why, friends, once again important, please keep these principles in mind, so that if and when any counter submissions need to be given to the tax authorities, or during the course of your transaction whilst advising to your client, these principles should be referred to, these decisions should be referred to, and you may accordingly advise your. Moving ahead, just in terms of understanding any chargeable to tax, there was an instruction number 2 in 2014 given by the CBDT. It says it has been made by the remitter under section 195(2). The revenue authorities will determine the appropriate portion of the payment which is chargeable to tax in India. So once again, the intention is very clear that what is chargeable to tax in India is not the gross sum, but the income component embedded in that remittance amount. The instruction also says that payer will be treated as a defaulter for not withholding taxes only with respect to the portion of the income element or the payment which is chargeable to tax in India, right? And once again, friends, important to refer to circular number 3 of 2015, which was of course issued in the context of section 40 AI, and which clarified that for the purposes of making any disallowance of other sum chargeable under section 40 AI, it is only the appropriate portion of the sum which is chargeable to tax which shall form the basis of such disallowance. And friends, the underlying rationale is, we all know that section 40A deals with disallowances of expenses when tax was supposed to be withheld on that expenses but has not been withheld. Under the domestic, if the payment is being made to a resident, the disallowance is now restricted only to 30%. But insofar as payment is being made to non-resident, one should rely on circular number 3 of 2015 if the officer is intending to disallow the entire remittance amount. But you are of a different view to say that no, the income component embedded in the remittance amount is lower than the entire remittance, and hence by virtue of this circular, please disallow only that appropriate portion of the remittance. Okay, so friends, just to quickly summarize, withholding tax under 195 will apply as if the entire payment is not chargeable to tax, there is no need for withholding. If the entire payment is chargeable to tax, yes, tax will have to be withheld. If only the part payment or part of the entire consideration is chargeable to tax, withholding will have to be done on appropriate portion of the sum which is chargeable to tax. But with that, it's important to say that exercise caution, please do your due diligence, obtain all the necessary documents, information, confirmations, declarations, so as to be completely sure that it is only that component which is chargeable to tax which needs to suffer the withholding. Because as I have mentioned, otherwise the responsibilities and the obligations on the remitter is onerous, interest and penal consequences will follow. Now, in terms of quantifying the withholding tax, the rate specified in the Finance Act or the rate specified in the DTAA, whichever is beneficial, will be the applicable rate for withholding. As we discussed, higher rate of tax under 206AA will become applicable if PAN is not furnished. This is now pretty much relaxed by virtue of Rule 37 BC. So if, let's say, the non-resident provides the 4 pieces of information which has been listed in Rule 37 BC, which is the name, address, email ID, tax identification number of their home country, and the TRC, which is the tax residency certificate, then you need not go under 206AA and deduct at a higher percentage. You can still continue to be governed by the rate specified under the treaty or the Finance Act. One very important point is that the rate which is specified in 206AA, so if, let's say, the non-resident is not able to provide this information which has been listed in Rule 37 BC, and the non-resident of course does not have a PAN, then you are governed by 206AA. Please remember, 206AA is starts with a notwithstanding wording. It's a non-obstantive section. The absolute rate of 20% does not need to be increased by surcharge and cess. We have a few decisions now on this particular matter. One of the decisions I've referred it over here, so please rely on it if in a case you are compelled to withhold tax under section 206AA. And of course, in case where a nil or a lower withholding certificate has been obtained from the tax authorities, you do not need to withhold tax in the case of a nil certificate. And if it is at a lower rate, please follow the certificate which has been given by the tax office. Now, many a times these payments are made in foreign currency. So what is the exchange rate that needs to be adopted? So Rule 26 of the income tax rules provides that the SBI telegraphic transfer buying rate on the date when you are obligated to withhold tax needs to be adopted. Forex fluctuation between the date of deduction of tax and the date of remittance is to be ignored. Now friends, here a very practical point which I would like to raise before all of you is that insofar as ascertaining the income of the non-resident which is chargeable to tax in India, you need to go to Rule 115 of the income tax rules. Right? And let's say, for example, the non-resident is earning capital gains income. And let's say that capital gains income is being earned as of today, 8th of January 2022. So what Rule 115 says is the SBI TT buying rate prevailing on the last day of the month preceding the month in which the transaction has been entered into. So because the transaction is entered into Jan 2022, you need to take the TT buying rate as of December 31, 2021 to ascertain the income of the non-resident in India. Okay, and for different heads of income, there are different dates which have been provided to consider the SBI TT buying rate. However, insofar as the withholding is concerned, as we have seen, Rule 26 provides the date on which you are obligated to withhold tax. So if your transaction is consummated today, whilst for ascertaining income, you will go to Rule 115. For ascertaining the rate for withholding taxes, you will actually go to Rule 26. So friends, please bear this in mind. This is a practical nuance. It will be very important for you to advise your clients adequately on this front because the volume of these transactions, especially the ones which I'm talking about, the share transfer, stock transfer, run into millions. Any shortfall in terms of any withholding could lead to a substantial tax exposure, including interest and penalty for the client. Now moving on to the grossing up concept, and grossing up has been given under section 195 capital A. So as we discussed a few some while back, that many a times the non-resident will contractually agree in such a manner with the resident that any withholding or any taxes which are levied in India, be it an income tax or any other indirect taxes, will be on account of the resident remitter itself. And that is why the tax which needs to be withheld will be on account of the resident remitter. So how this grossing up concept works, friends, is that if let's say you were to make a payment of $100 to the non-resident, and the arrangement is such that the tax is on account of the resident remitter. Let's say for simplicity's sake, the tax rate is 20%. okay, on such income. So how we need to understand or interpret this is that the $100 which gets remitted to the non-resident is actually net of taxes. Okay, so you gross up the remittance amount, which is 100, make it by 20%, so that 125 becomes actually the gross amount which is chargeable to tax in India. You make a computation to say that 20% tax on this 125 is $25. So you withhold that $25, make a payment to the government on your own account, and then the balance consideration, which is 80%, okay, of the total consideration after withholding 20% tax, which in our case is $100, you make that remittance of $100 to the non-resident recipient. So that's how this grossing up concept will work, friends. Fairly simple in that sense, but there's just that arithmetical element involved. Please take care of it, and that is why once again becomes important to read the agreement, peruse the contractual understanding between the remitter and the between the resident and the non-resident very thoroughly. And finally, in terms of interplay between equalization levy and 195 provisions, if the payment is being made for specified services as has been defined in the income tax law on which equalization levy has been levied, then there is no need to withhold any TDS under section 195. Now friends, we move on to a very important concept, which is the MFN clause, most favored nation clause. And India has entered into several treaties wherein this most favored nation clause is there. Okay, so let's understand what this concept is all about. The MFN clause states that where a favorable terms of a DTAA, okay, where favorable terms in a particular DTAA in respect of any income stream, example FTS, royalty, dividend, is subsequently granted to a third country, okay, by let's say India, the country with which India has entered into a DTAA earlier is saying, you please extend me those favorable clauses, you please extend me those concessional clauses to my treaty as well. Okay, so let's take an example. India Netherlands treaty has a MFN clause. Okay, so India and Netherlands, when they entered into the double tax avoidance agreement, there was an MFN clause which was also bilaterally negotiated and incorporated in the treaty. And let's say the dividend rate for hypothetical purposes is 15%. Okay, this treaty was entered into 1989. Okay, between India and Netherlands, the treaty has been entered into in 1989. Now let's say hypothetically India enters into a treaty with another country in 2005. Okay, now and India gives a withholding tax rate on dividends at 5% to that particular country. Okay, that's when this MFN clause will get triggered in the India-Netherlands treaty, where by virtue of this MFN clause, Netherlands will now come back and say to India, hey India, look, after we have entered into the treaty, few years later, you have given a concessional, a beneficial tax rate to another country, which is 5% in our example, vis-a-vis the 15% which is prevailing in the India-Netherlands treaty. So by virtue of this MFN clause, you now also give my residents, okay, so the residents of non-resident who are dealing with India, a 5% withholding tax rate insofar as their dividend income is concerned. Okay, and friends, just to give you a rationale as to why countries enter into a MFN clause, it's because after entering into a treaty with that particular country, if the source country goes and enters into a treaty with another country and gives them the beneficial rate, it may hamper the trade and the commercial activities between the first two countries that we discussed, right? So the Dutch, the Netherlands is cognizant of this and says that if my shareholder is going to earn is going to be taxed at 15, but some another country's shareholder is going to be taxed at 5, investments may not flow into India from my country. People would structure the transaction or structure their entities from that particular country, and I may lose out on on foreign investments. So that's where this MFN clause is inserted. I hope this is fairly clear to everyone. MFN clause, friends, is generally prospective, and it is either in the form of a lower tax rate or the scope of income which is liable to be taxed is restricted or narrowed down. And friends, when I say it is prospective, so just to continue our example, the India-Netherlands Treaty was entered into in 1989. Let's say India has entered into another treaty with another country in 2005. And once this MFN clause is triggered in the India-Dutch Treaty, the beneficial rate of 5% by virtue of this MFN clause will be available to a non-resident from an India perspective and a resident of the Dutch only from 2005 onwards. It cannot be availed for that 16-year period between 1989 to 2005. Okay. Generally, friends, along with the treaty, the two countries who have bilaterally negotiated the treaty will also enter into protocols. There will be notes which will be exchanged between the two countries. So MFN clause will either be forming part of the treaty or will be forming part of this protocol or the notes exchange. So very important for us to read the treaty and the protocol and the attached and the supporting documents there too, for us to understand what is the scope of MFN and how is it that it is going to be triggered. So different countries may bilaterally negotiate that the triggering of MFN clause is automatic. That is the moment, in our case, India has entered into the treaty with another country in 2005, or the MFN clause in the protocol would say that there is a need for a notification to be issued by both the countries. Then both the countries have decided, that a notification needs to be issued. So that is a requirement then. Or there is another category which says that subject to a negotiation followed by a notification, which means that India has told Netherlands that, hey, look, even if I give someone a beneficial rate, your MFN clause will not get triggered automatically. We will once again sit on the table. We will tell you our reasons of giving them a concessional rate and why we cannot extend that rate to you. So there will be a negotiation, which after a decision is reached will be followed by a notification. Okay, so there are different ways in which the MFN clause may get triggered, and that is why important for us to read through the protocols and the exchange notes to understand the manner of the triggering. And just a few instances, India has a MFN clause in its treaty with Netherlands, Belgium, France, Hungary. So please, whenever you are making a payment to the residents of these countries, please evaluate thoroughly whether you are also giving them any benefit which is due to them under the MFN clause. And friends, I have referred a decision of concentric services in my presentation over here. It's a very, very good decision. I would sincerely request all of you to go and read it. It is laying down or explaining the concept of MFN clause very well. It's a recent decision rendered just in 2021. I'll just take a couple of minutes to briefly explain the decision, but please, friends, go and read this decision. Here what had happened was the Indian company was making a dividend payment to its non-resident a Netherlands shareholder, and whilst the DTAA rate under the India-Netherlands treaty is higher, India has entered into a treaty with Slovenia in 2005. Okay, and by virtue of the MFN clause being triggered, the Indian company made a lower withholding tax petition application to the AO, requesting to withhold at 5% only by virtue of the rate given in India-Slovenia treaty and triggering the MFN clause in India-Netherlands treaty. So this application was rejected by the officer. A writ was filed for the Delhi High Court, and the Delhi High Court has laid down a very beautiful decision, very educative, has referred to international tax principles, has also referred to how the Netherlands has particularly looked at the MFN clause by virtue of India entering into a treaty with Slovenia, Lithuania, and Colombia, which have all been referred into this decision. And finally, the Delhi High Court has concluded to say that, has opined to say that the withholding which needs to happen from India to the Dutch shareholder on account of payment of dividend will happen only at 5%. Right? So MFN clause was invoked, was upheld, and the withholding was allowed at a concessional rate. Similarly, friends, while quantifying the what is the withholding tax that is required to be done and the rate, there is another concept that we need to understand very thoroughly, is that is of the beneficial ownership. Now, this concept finds place in a lot of clauses under the DTAA, and as a matter of fact, near to our home, we also find the concept of beneficial ownership articulated in several of the sections under the domestic tax law, which is section 222 pertaining to or defining dividend, section 79 under the Indian income tax law as well. So let's look at this, this term and how various authorities across the globe have interpreted the term in their own manner, right? So we have IBFD who has defined this term. We have the model conventions, the OECD and the US who have also defined. So let's look at some of the definitions. The OECD says that the term beneficial ownership is not to be used in a narrow sense, has to be interpreted in a purposive sense. Okay, it has to go in line with the objects of the convention, which is the DTAA entered into between the two countries. It also goes on to say that agents, shell companies, conduits, nominees are not to be regarded as beneficial owners. Okay, the US model convention interprets the term beneficial owner to say a person if the income is attributable to him for tax purposes as a resident of the United States. So that is how the US model convention interprets the term beneficial owner. Friends, we all know Professor Klaus Vogel, who is an authority in it, in himself as an expert of international tax. His commentary on the international tax is simply amazing. It refers and provides a lot of guidance to us. He defines the term beneficial ownership as, very simply, a person who is free to decide where he wants to dispose that income, how and in which manner he wants to utilize that income, right? Whether he further defines to say whether or not the capital or the assets should be used or made available for use by others, and how the yields from them should be used. So basically, friends, when the income is at the disposal of the recipient, he can be construed to be a beneficial owner, right? So friends, if you are all aware how these international structures typically work, let's say there is a large corporate based in US, UK, Canada, and who wants to enter into, let's say, a jurisdiction like India. Now they would want to avail concessional withholding tax rates under the different treaties which India has entered into, and that is why they would set up an intermediary holding company, let's say in a jurisdiction like Singapore, Netherlands, Mauritius, and so on, and from there they would make an investment into India. So when India declares dividends, it first declares dividends to its immediate holding company, which is located in one of these intermediary jurisdictions, and then this intermediary jurisdiction will upstream the dividend to the ultimate parent. Now, many a times, friends, the intermediary holding company is not a beneficial owner of the dividend that the Indian would be remitting, and it's a fact specific exercise, but you need to evaluate whether the intermediary holding company is indeed a beneficial owner or not. And for that purpose, friends, ask for documents like the articles of association of that company, the board resolutions, the contractual arrangement which the intermediary holding company may have entered into with the ultimate parent. Because friends, practically what happens is the intermediary holding company is obligated by one of these documents which I just mentioned, that it needs to upstream the dividend on a back-to-back basis as soon as the very next day when it receives the dividend. And in that sense, if you try to go by the definition of Professor Klaus Vogel, it is not really the beneficial owner of that receipt of that dividend. It is not free to decide where it wants to dispose of that income. Okay, it is contractually obligated to upstream the dividend on the very next day. Now, in these kind of situations, friends, you may be obligated to look through and not give the concessional tax rate benefit to the intermediary holding company by virtue of the lower rate given in the DTAA. So please call for these documents. Please try to understand the transactions a little, the structure a little bit in depth. If again over here, if the withholding is not done adequately, there are onerous responsibilities, interest, penalty, and so on that that will follow to the resident remitter. Now, one more question which comes up is that whether the provisions of section 206AA override the rates which have been prescribed under the DTAA or not. And as we have already discussed, the implication of 206AA have been restricted now to a great extent post introduction of Rule 37 BC. However, even if for that matter you are still getting covered by 206AA, okay, then I have given it over here. This ratio, this principle or this issue is fairly settled now. We have quite a few favorable rulings to say that no, 206AA will not override the treaty provisions because it starts with a non-obstante clause. Hence, it cannot. It is not a charging section, so it does not override 4 and 5. And section 90 subsection 2 very clearly says that to the extent the treaty provisions are beneficial, the provisions of domestic tax law will not apply, right? So please quote these decisions if you are faced with this situation, in any of your clients, matter. I've also given one illustrative example of how the crossing up will work. We've already discussed this, so in the interest of time, I'll not go into it, but this is essentially in line with what we have discussed. Now coming on to section 195.2 and 195.3, which are the remedies which have been given to the remitter under 195.2 and the recipient under 195.3, wherein they can approach the tax office with the transaction and make an application requesting the assessing officer to ascertain that what is the sum which is chargeable to tax from the entire component of the remittance, right? And then the officer under 195.2 will direct the remitter to either withhold tax on a lower amount on the entire consideration, or will provide a tax rate only on the to be deducted only on the income component of the remittance. So here under 195.2, friends, the possibility is to obtain a lower withholding certificate as well as a nil withholding certificate, right? The officer is obligated to ascertain the appropriate portion which is chargeable to tax, and for that purpose the payer, the remitter, is obligated to provide all the information and documents to the assessing officer. So let's take our example where the resident is buying an immovable property from the non-resident. Now, in order for the assessing officer to ascertain the quantum of the capital gains which the non-resident will end up earning from on account of the transfer of this immovable property, it becomes imperative for him to go through the purchase agreement of the non-resident at the time of purchase of his property, right? And the other documents provided the non-resident is making claim for other expenses as well. Now, if these documents are not provided, the officer will not be in a position to compute the appropriate portion of such sum which is chargeable to tax. So here there is sometimes a practical difficulty which the remitter and consequently the department faces because certain documents may be sensitive. The non-resident may not be comfortable sharing the purchase agreement with the resident, and hence these documents may not reach to the tax office consequently, right? So only and only if the non-resident is willing to cooperate and provide all the information to the resident remitter can the resident remitter really approach the assessing officer under section 195.2. Now, Rule 29BA provides all the procedural aspects in relation to making an application under section 195.2. The application has to be made in form 15E. It has to be verified digitally either by using the DSC or the electronic verification code. The AO will then determine the appropriate sum chargeable to tax based on the domestic tax law, as well as after taking into consideration the relevant provisions of the DTAA. And for this, once again, if the non-resident wants to take recourse to DTAA, he will have to provide documents like 10F, no PE declaration, TRC, and so on, so that he is eligible to take or avail the beneficial provisions under the DTAA. And while examining the application, the AO will have to consider that what is the tax payable on the estimated income for the financial year for which the application is made, what has been the tax position in terms of the non-residents assessments, return income or estimated income over the past 4 years, what is the existing subsisting liability of the non-resident under the Indian Income Tax Act and the Wealth Tax Act, and what is the advance tax or the TDS or the TCS which has been discharged for and on behalf of the non-resident for the current year, right? And then finally, once the officer has evaluated all these things, he has the information, he has ascertained the appropriate amount chargeable to tax, he will issue his certificate. This certificate will be valid for a particular financial year or for a particular period or for a particular quantum of payment, right? And once either of the conditions which has been mentioned is expired or has been met, you need to approach the tax office for a fresh certificate, or you can also, if it is a time-bound certificate, then you can approach 3 months prior to its expiry and for a renewal of the certificate. Moving on to section 195 subsection 3, friends, here the payee, which is the recipient, has a power or has an option to approach the tax office and make an application to the officer and request him to grant a certificate that the amount which is being paid to me or the amount which I'm supposed to receive be allowed to be repatriated to me without deduction of any tax under 195.3. So there is this very important distinction, friends, between 195.2 and 195.3. Whilst under 195.2, the remitter can approach the tax office for a nil or a lower withholding tax as well. Under 195.3, the payee can approach only if the entire amount which is chargeable to, entire amount of remittance is not chargeable to tax in his view. Okay, if let's say the payee wants to approach the tax office for a lower withholding tax amount, then he can do so under section 197, but not under 195 subsection 3. Okay, so very important distinction to be kept in mind. And of course, if the payee wants to make an application to the income tax office, it needs to have a PAN number in India, it needs to have been regularly assessed in India, and those are all the conditions which have been given down under Rule 29B. There are several forms which have been given and conditions which have been laid down. So if the non-resident payee is fulfilling these conditions, he can make an application to the tax office under 195.3. Now friends, 195 or non-residence taxation, and we have looked at the domestic tax law, we have looked at the DTAA. Now with the advent of MLI, okay, the scenario has got complicated multifold insofar as a non-residence chargeability to tax is concerned. I understand that on day one, Siddharth has discussed the MLI, has given you guys the overview of it, so I'm not going into the background and the overview of MLI. I've nevertheless put in a few slides for everyone's benefit. Please go through it, but I'm sure most of this has already been covered in his session, right? Now let's come and evaluate the impact of MLI insofar as the withholding tax when it comes to a non-resident's income chargeable to tax in India is concerned. So in cases where MLI is still not applicable, there is no change. You continue to evaluate your withholding tax implications under the Act, under the DTAA, obtain the relevant documents like Form 10F, TRC, No P declaration, and continue your withholding as before. Sorry. Now in case where MLI is applicable, right? So where the India has also notified that country and the other country has also notified India, and also on that relevant article, both of the countries have expressed their expressed that they would want this article to get triggered. So now the DTAA has to be read along with the MLI, and which is then now referred to as a covered tax agreement, as a CTA. Now one of the principal purpose test is one of the test which applies, or which is a minimum standard, so to say, right, and which applies immediately once you have opted for MLI and the other country has opted for MLI. So your CTA will be governed by the principal purpose test, which means that even if one of the objectives is to obtain a tax benefit, right, and the structure has been set up in such a manner, you have entered into India to avail tax benefit, right, or to avail one of the objectives is to obtain a tax benefit under the treaty, then the PPT clause will get triggered and possibly you could be denied the benefits under the DTAA, right? So friends, you would have heard in that session that the PPT is a very dangerous test which has been there. The structure should be set up for commercial considerations and not to obtain tax benefit, right? And here I have just drawn a reference to one of the paragraphs in the in the Shom committee report, albeit it is in the parlance of GAAR, right? But it just goes on to show the onus which has now been placed on the remitter, on the payer in this era of MLI and GAR, right? So this para reads as, there is a responsibility cast on the payer of any sum to a non-resident under the Indian tax laws in the form of a withholding agent of the revenue as well as the representative assessee of the non-resident payee. The payer is required to undertake due diligence to ascertain the correct amount of tax payable in India, and in case of any default, it becomes the payer's liability to pay. So friends, if you read this paragraph and understand it, the onerous responsibilities now cast upon the payer is that you need to exercise caution, you need to exercise adequate due diligence to ensure that your GAR, your MLI and the related provisions thereunder are absolutely being complied with before you make a decision or arrive at a conclusion that this remittance to the non-resident is not chargeable to tax in India, right? It is like the payer is supposed to sit in the chair of an income tax officer and then decide whether I'm supposed to withhold tax or not, or whether this income is chargeable to tax in India or not. But friends, this is easier said than done. It's practically very difficult to kind of push the non-resident and obtain a lot of information from them, even if you wanted to carry out this due diligence or this analysis at your end. And let's take a few examples where, let's say there's a one-off transaction happening by an Indian between an Indian resident and a non-resident, or an Indian company or a corporate is dealing with a very large global MNC. Those guys are not going to be willing to share any information like what is the genesis of setting up a particular structure, are they PPT compliant or not, have they ensured that they have taken a legal opinion to to safeguard themselves and to ensure that they are in compliance with the principal purpose test under the MLI or not. And hence it becomes very important for us to ensure that we are advising our clients, giving them enough safeguards. And in the following few slides, I have tried to address that and which will help us safeguard our clients' interest. Because if we don't do that, as we have been discussing, the consequences are expenses are disallowed, interest and penalty consequences, and finally we could also be exposed to the tax exposure itself, right? If we are regarded as a representative assessee or as an agent of the non-resident under section 163. And these are just some few select key selected articles under the MLI under which now you will have to be cognizant of the of the MLI articles, read it along with the DTAA, and then go ahead and decide whether tax is to be withheld or not. But just to give you an instance, friends, look at the practical difficulty that will come up when you are trying to do this analysis, right? Let's take, for example, take Article 8. The shares are to be held for a minimum period of 365 days to avail the beneficial or the concessional tax rate provided under the CTA. So now, after evaluating PPT and all, you also need to ensure that the person to whom you are paying dividend, okay, and if you are giving them a concessional or a beneficial tax rate under the DTAA read with MLI, which is the CTA, the shares have to be held for a minimum period of 365 days by that particular shareholder. Now, many a times there are corporate restructuring, reorganizations happening at a global level, and in that country that merger may not be regarded to be a transfer, and it may be construed that that entity is only holding shares from day one, even prior to the merger happening. Now, how do I, as an Indian resident who is, declaring dividend to that particular company, be aware or be well versed or be cognizant about these kind of provisions under those countries' domestic tax law? Even if you look at Article 4, it says that in case of dual residency, until and unless the competent authorities of the two countries are resolving or decide upon the jurisdiction of residence of that particular non-resident, you cannot provide any relief or exemption under the CTA to that non-resident. Now, as a resident remitter who is making a payment to the non-resident, how am I to know that there is an ongoing discussion between the competent authorities of two particular countries? And if I have to make a payment today, if I try to withhold tax under the domestic tax law, the non-resident is not going to accept it because the tax rate will be substantially higher vis-a-vis the DTAA, and the transaction may even fall through. So if I give the benefit, then I'm in violation or I'm in non-compliance with the CTA under Article 4 of the MLI. But otherwise, the transaction may fall through itself because the non-resident may not be willing to accept a higher withholding. So a lot of practical issues and nuances will come along our way when we are advising our clients in terms of withholding taxes, especially where India has entered into India's DTAA with the other countries now considered to be a CTA. So in this backdrop, friends, what do we do? How do we move forward? How do we move ahead? So very important that first, when a client approaches you and requests your advice on a payment to be made to a particular non-resident, please do a detailed matching exercise in terms of whether that country is also subscribed to MLI or not, whether then for a particular article has India and that other country have both notified each other or not, whether the option which has been selected under a particular article is also matching or not. So please do this detailed matching exercise. For your reference, you could also refer to the synthesized text, right, which has been printed on the income tax portal on the Indian income tax website, right, and which is nothing but a culmination of the original DTAA read with the the articles which have got incorporated after the MLI has been subscribed to, and which is now a CTA. Friends, please remember, synthesized text is not a legal document. It only has persuasive evidence. So tomorrow, if we have relied upon synthesized text in the court of law, we will not be able to take a position that, look, this is what CBDT had printed on its website. I have relied on that, so CBDT is bound by it. That proposition will not work. Synthesized text is just a helping document to say that this is how the treaty is to be read, right? It does not interpret or does not give CBDT's view. So once you have done all these things, then you evaluate the impact of MLI on that particular transaction. We need to ensure that our client maintains robust and adequate documentation so that we are able to help them position, safeguard their position, also obtain a lot of declarations, confirmations to corroborate and support your claim, obtain indemnities. Declarations can be obtained, along with your no P declaration and your tax residency certificate in terms of, the structure or the transaction has not been entered into obtaining treaty benefit to say that PPT test is being satisfied. You take a declaration or a confirmation that the recipient is indeed the beneficial owner. Try and take some supporting documents for that as well, and the other declarations which I have listed over here. So if it's a transaction of a very large volume, please ensure you get all these declarations on the letterhead of that particular non-resident, so that at least an initial, a prima facie due diligence has been undertaken by your Indian client while making a remittance to the non-resident. This will at least be the first firewall so as to say that I have exercised caution and diligence. And finally, friends, please obtain appropriate indemnities, and this has become very important now. A lot of transactions, share acquisitions, share transfers of very high value are happening nowadays, especially in the last 2 years. It is many a times a non-resident may have entered into India from Singapore, Mauritius, and they may want to be taking the the treaty benefit, especially under Article 13 capital gains. They might push for a complete non-withholding on the consideration that is being paid to them. Of course, these are commercial discussions between the two parties, but as advisors to your clients, please advise them to obtain adequate indemnities. This indemnity should not only cover the tax exposure amount, but should also cover interest and penalty. The indemnities should also, you should obtain the indemnity for a cost as well that you would be incurring for defending this position before the court, before the tax authorities or in a court of law. And finally, ensure that the indemnity is for a sufficient period of time, right? So even if the reopening was to happen after 3 years or 10 years, now under the new reopening scheme of reopening scheme under the act, your client is still safeguarded and is still indemnified. Of course, we need to obtain a lawyer's expertise on this insofar as to draft the indemnity is concerned, but purely from a tax perspective, please ensure all these points are adequately captured in the indemnity. Here I've just given a couple of screenshots. This is the MLI matching database on the website of OECD itself. This is a very, very helpful tool. It gets updated on a real-time basis. So here you can actually see if you select India and the other country with whom you want to evaluate and check that whether a particular article of an MLI is applicable or not. So you just select the country and the entire matching happens from the OECD's database. For example, over here, Article 4, Article 5 doesn't apply between India and Singapore. Article 6 and 7, which is the minimum standards of PPT, is of course applicable. So that's what has been written over here. So likewise, every time your client needs to make a payment outside of India to a non-resident, and if please go to this website. I've given the link below. Ensure that you are doing the matching of the positions taken by the countries on a very real-time basis. Here I've given a screenshot of how the synthesized text looks on the Indian income tax website. So this is the India-UK treaty. Like how in Singapore, Article 4 is not applicable because India is subscribed. Singapore has not notified India under Article 4. Under the India-UK treaty, India and UK both have notified each other under Article 4 of the MLI. Okay, so now Article 4 of the treaty, fiscal domicile, will read as Article 1, paragraph 1 and paragraph 2 as before from your erstwhile DTAA. Now, however, the paragraph 3 has been replaced. So now you will need to read paragraph 1 and 2 with Article 4 of the MLI. And this is how you will read, your erstwhile DTAA with the MLI, which is now the covered tax agreement. Over here also, friends, I've given the link at the bottom of the page. Please have a look at it, those who are interested and want to understand how these things really work. Insofar as the procedural aspects is concerned, I've given down what all compliances need to be taken in terms of date for deduction, when it is to be paid, when the TDS certificate is to be furnished, and what are the compliances that needs to be taken at the time of making the payment. So we are all aware that we need to file a form 15CA. 15CA is of course to be filed by the person actually making the payment. If form 15CA has multiple parts, we'll see that in the next slide. 15CB is a certificate which is to be issued by the chartered accountant. We certify that to the best of our knowledge and whether in our view whether this payment is chargeable to tax in India, and if yes, under domestic law which sections, under the treaty which articles, and then we give the withholding tax rate, compute the withholding tax and certify the withholding tax amount, right? There is also a need to file the withholding tax return. So this is filed in form 27Q. There are 4 quarterly returns to be filed. I've given the withholding tax rate. Now, very important that when you're advising your client, okay, what are the procedural aspects? What is the process that you should be following in your mind? What is the steps that you should be following? So when your client will come to you with agreements, invoices, and ask your advice on whether this is chargeable to tax or not, and whether any withholding needs to happen. So you've decided, you've evaluated, you've analyzed. Now to make that remittance, right, you will start with the process of filing of form 15CA and 15CB. As we discussed, 15 CA is to be filed by the company, and 15 CB is our certificate which we certify in terms of the withholding to be done. We'll of course obtain documents like TRC, Form 10F, and no PE declaration if the non-resident is going to avail the benefits under the DTAA. As we have discussed, friends, now in the light of this era of GAR and MLI, please obtain adequate indemnities, adequate declarations. These declarations have to be substantive. Please ensure you are advising your client to exercise caution and diligence at every point in time. If the non-resident has a PAN in India, please obtain a self-certified copy of their PAN. If they do not have a PAN, then ensure that Rule 37 BC requirements are met with. We've already discussed that. And please take a declaration from them that they are eligible to obtain treaty benefits, that the PPT test is complied with. Only once you have all these documents, friends, please go ahead and file 15 CA and 15 CB. Ensure that adequate diligence has been done. Moving on to the filing of Form 15C and 15CB, Rule 37 BB has specified the manner and the form in which the remittance will be done and what forms are required to be filed. Now, Form 15CA has 4 sections. If the remittance amount is less than 5 lakhs, you need to fill up Part A. Of course, below 5 lakhs but chargeable to tax. If it is higher than 5 lakhs, but it is after obtaining certificate under section 195(2)(3) or 197, then you need to fill up the Part B of Form 15CA. If the remittance is higher than 5 lakhs and chargeable to tax, you fill up the Part C. And then finally, when the amount is not chargeable to tax at all, you need to fill up the Part D of Form 15CA. Both these forms, friends, are now to be furnished electronically. Manual forms are not required. Only when in the interim the website had issues, the income tax portal had issues, there was a direction given by the CBDT that the banks would accept Form 15CA, 15CB in the physical format. But now once again 15 CBs are being uploaded electronically. We are doing that on a regular basis, not facing any substantial issues as such. Of course, many a times there are certain technical glitches, but I think many of them have been ironed out. Now, insofar as the transactions for which 15CA is or there are exemptions given under Rule 37 BB, that is the 15CA, 15CB is not required. There are 33 specified transactions which have been given, and the remittance by individuals under the LRS scheme. And these 33 transactions, friends, essentially pertain to capital account transactions, infusion of capital, your traveling expenditures, your typical imports, and so on. The exhaustive list which has been given, one can refer to that. Now, very quickly, another procedural aspect is to obtain the tax residency certificate, from the government or from the tax authority of the country in which the non-resident is situated. The requirement to obtain a TRC is for all the non-residents, be it an individual, corporate, partnership, LLC, etc. And it is also to be obtained irrespective of the quantum of the payment it is receiving from an Indian remitter. Rule 21 AB sub-rule 1 of the income tax rules provides for the information that needs to be furnished in Form 10F under the income tax rules. Now, this has been a contention, friends, where whether the TRC will be regarded as a conclusive proof of tax residence and whether the tax authorities should or would go or not go beyond the TRC to examine the residential status of the non-resident. We have the Supreme Court decision in Azadi Bachao as well as CBDT circular in 789, which have very categorically laid down that once the resident has been able to obtain the TRC from the non-resident, right, that should be a conclusive evidence regarding the tax residential status of that particular non-resident, because ultimately it's a certificate issued by a government, by a authority of that particular country, and one needs to respect that. If for whatever reason TRC is not available, and this has been a very common feature over the past 18 to 20 months, friends, where because of the pandemic, because of the lockdown, many government authorities were not able to function and issue TRCs on time. and that is where one may take recourse to this particular decision in SCAPS industries. However, I should once again draw everyone's attention. This is an extremely litigative proposition, because if you are not able to obtain TRC, right, and you rely on any other document to say that okay, this particular non-resident is a resident of this particular country, and that's why I'm giving them a treaty benefit, your case has to be made very strong that why you were not able to obtain TRC. What was the compelling reason that because of which that non-resident could not obtain TRC from his government, from his tax department, and why the same could not be provided to you. However, if you must, please rely on this decision, but exercise caution, as it is extremely prone to litigation, this view. However, if you were to do, please ensure you get documents like certificate of incorporation of that particular non-resident, the board resolutions, board minutes, the financial statements of that particular company, the tax returns which may have been filed by that particular non-resident in his home country. All these documents will at least build a safeguard, a firewall for your client in absence of the TRC being made available by the non-resident. Friends, this one slide I want everyone to take note of. What we have discussed over the past maybe 15-20 minutes in terms of the declarations and the indemnities to be obtained. I have put down a few pointers over here. This will be helpful to you, is what I hope. Please obtain declarations and indemnities on these lines for your clients whenever they are entering into a transaction with a non-resident. These declarations and confirmations will help to build enough safeguard for your clients, and will help demonstrate to the tax authorities if any litigation comes up, that we have exercised our enough diligence, we have obtained all these documents from the from the non-resident. So beyond a point, there is very little that me as a remitter can do about the non-resident status. But please take note of this. I have covered all the important points, like who qualifies to be a person under the CTA, what are the whether it is complying with the PPT or not, beneficial ownership, whether they have a POEM in India, a PE in India, so on and so forth, right? Just to very quickly summarize the key consequences of no withholding. As we have discussed, there will be a disallowance of expenses insofar as whenever the tax has not been deducted. But by virtue of Circular 3 of 2015, the claim that should be made, or the proposition that should be made, is that only to the extent of the income component in the expenses what needs to be disallowed. Similarly, under 40A IC and 40A3, there will be certain expenses which will be disallowed if the conditions under this section have not been met, and along with the disallowance of this section of the expenses, interest and penal consequences will also follow. And these are just some very ancillary sections which I was asked to cover. Friends, these are very specific sections: 196 capital A, B, C, and D. The trigger event in terms of when the withholding tax liability arises, that has been laid down. What is the withholding tax rate has been clearly laid down. These are very specific sections. Very rarely you would come across withholding required to be done under this, and as and when you come across, please refer to these sections where it is explicitly given the need for withholding as well. Just one important point that I wish to address over here is that the amendment which has come by virtue of Finance Act 2021 in 196 capital D. So 196 capital D has been amended to say that withholding tax rate of 20% or at the rate prescribed in the DTAA, whichever is beneficial. So now the section itself has said that you can withhold at 20% or you can refer to the DTAA, and whichever is beneficial, that tax rate you can apply to the non-resident on remitting this income from India. However, insofar as 196 capital A, capital B, and capital C is concerned, whilst the PILCOM decision has laid down that under 194 capital E, because there was no reference to the rates in force, you cannot go to the DTAA. But looking at the proposition that section 90 subsection 2 applies to the non-resident to the extent the DTAA provisions are beneficial to the to him vis-a-vis the tax domestic tax law provisions. To my mind, there is a good case to be made that even under 196 capital A, capital B and capital C, if the DTAA rates are beneficial, you could still go and take shelter under the DTAA, right? So friends, with this, I would like to conclude my session, but just before concluding, once again, maybe a couple of minutes to emphasize the importance of this particular topic in this era of GAR, MLI. Absolutely important that we exercise adequate caution, adequate diligence, obtain all the necessary indemnities and declarations, ensure that our clients' onerous responsibilities are safeguarded and protected, and we also as professionals are exercising our professional responsibilities and duties judiciously. With this, I end my session and I thank all of you for a very patient hearing. I just ask the organizers if we have time for certain questions, or I'm happy to answer them one-on-one later over email or a call as well. So I've given my contact details over here. Friends, please note this. I'm happy to talk to anyone or answer your queries over an email if time is short right now and we don't have time to address all the queries.
So we will mail the questions, sir, because we are running short of time.
No problem. No.
Yes, thank you, sir.
Sure. Okay.
Thank you very much for your exhaustive and lucid presentation and uninterrupted presentation, sir. Thank you very much for being here today. Madam, you can introduce the next speaker.
Thank you very much.
Yes,
Thank you, Karthik.
welcome, sir.
Yeah.
1 minute, I'll just stop sharing my screen.
Sir, I took the rights, sir. No problem. I took the rights.
Oh, okay, you've taken. Okay.
Stop. Thank you.
Thank you, sir.
Okay.
Thank you very much.
Thank you very much.
Yeah. Happy afternoon, friends. With this, we are entering yet another interesting session on taxing the digital economy through the significant economic sense. As we all are aware, to tax Indian source income on the strength of operating in online and digital space, the Indian tax regime has introduced the concept of theft as a measure to tax digital transactions in India. To shed more light on these issues, we have with us an eminent speaker, Aseem Chawala from New Delhi, and I, on behalf of SIRC and International Taxation Committee of ICAI, I wholeheartedly welcome you, sir, to this session. Before handing over the session to CA Aseem Chawala, sir, let me take this opportunity to briefly introduce our speaker. CA Aseem Chawala is the practicing lead at ASC Legal, Solicitors and Advocates in New Delhi, and he is a member of Bar Council of India and fellow Chartered Accountant and certificate holder of Comparative Tax Policy and Administration from Harvard Kennedy School and Vienna certificate in double tax studies from WU University of Economics and Business, Austria. Aseem has an extensive experience in advising on variety of tax matters, including international tax, inbound and outbound investment, structuring and cross-border tax issues, corporate and business advisory, exchange control and regulatory, and in money laundering laws. Aseem is well regarded for estate planning, inheritance, and family governance, and private clients, including national and international clients, high net worth individuals, justice and family offices. And Aseem was nominated by the Ministry of Finance, Government of India, as non-executive independent director on board of one of the largest state-owned general companies. And he is on the board of governors of business school in the National Capital Region, New Delhi, India. And I think is also a visiting faculty with the Institute of Chartered Accountants of India on economic offences, money laundering law, and international taxation. He is regularly invited to address various domestic and international forums and industry bodies. He has been consistently adjudged over the years as one of the leading tax experts
in the Asia Pacific region of Chambers and Partners, Legal 500, Who's Who Legal, Asia Law Leading Lawyers, Expert Guide, etc. And his views are often sought on contemporary tax and policy matters by the print and electronic media. So he has also several his credits, including his latest publication on Indian contemporary tax titled Finding a Straight Lane Between Twists and Turns, which has received encouragement from the leading international tax practitioners and honorable esteemed members of judicial fora. So with this very brief introduction, now I am going to hand over the session to our speaker, Aseem Chawala, sir. Over to you, sir.
Thank you. Thank you, Ms. Geeta, Honorable Chartered Accountant, for this very benign introduction. Good afternoon to friends from the esteemed SIRC, Honorable Chairman Shri Jalapati ji, Honorable CA Mr. Pannaraj, the Committee of International Taxation at the ICAI, the Secretariat, on this Saturday morning, and for the last couple of days, I understand that SIRC has done a very seminal job in terms of bringing together a national conference on international taxation. I believe I am the last man standing between you and the closure of this marathon learning exposition which you had for over several hours of enriched learning on various nuances of international taxation. It's a pleasure to speak to all the friends, senior and delegates virtually. I hope when things do settle down, we get an opportunity to board the Chennai Express and see you in person also. I have been asked to share views on aspects of digital business taxation, which finds its way in terms of a formal legislative prescription under the scheme of the Indian taxation. And I will not use the word Indian Income Tax Act, because the provisions relating to equalization levy were introduced by virtue of Finance Act, and they do not per se form part of, strictly speaking, the 298 provisions of the Indian Income Tax Act, so to speak. But suffice to say that Finance Act 2016, by virtue of introduction of chapter Roman 8, did introduce the concept of equalization levy, and then since introduction in 2016, we've seen two significant amendments in the scheme of equalization levy in 2020 and in 2021. Then comes equally important, as you heard in the introduction from the organizers, is the whole concept of significant economic presence, which was introduced in the scheme of Section 9 of the Indian Income Tax Act. Of course, it's an amendment which is in the scheme of the Act, and to the extent the treaty provisions are beneficial in nature, the taxpayer who is entitled to claim the benefits of the treaty would be entitled to apply the treaty provisions and see to what extent the treaty provisions do end up eclipsing the enhanced source-based prescription under Section 9, so to speak. I did ask the organizers to circulate a white paper, which I did very recently, on emphasizing on SEP, significant economic presence, and then I've done some reflections on how it overlaps with the other themes. I hope you will find the same a useful reading, and please feel free to offer your comments on the same. Then comes, thank you for sharing this slide. Then comes the aspect of the provisions of Section 194 which is another provision in the scheme of the TDS provisions in terms of prescribing the impost of TDS on e-commerce transactions. And then towards the end of today's deliberation, we will look at what is happening in terms of the international tax policy developments. And no discussion these days on international contemporary tax policy developments can be accomplished if we do not talk about Pillar 1, Pillar 2, which are global anti-base erosion rules, and the Pillar 2 prescription came very recently, which was unveiled by the OECD Secretariat about a couple of weeks ago only. And then lastly, we'll take up some other developments in terms of how India and US have agreed to call for a truce for a little while till the time the world at large, especially India, with United States does agree to global minimum tax, and as a result thereof, the US backlash, which we found in terms of imposing or potentially suggestive of imposing trade sanctions under US 301 of the USTR, suggesting the fact that our equalization levy, in other words, our digital tax, so to speak, DST, digital services tax, as it's popularly known as in the rest of the world in terms of a global lexicon, is contrary to the settled principles of international taxation. And since it affects largely the US companies, so US had identified India as one of those countries where they would where as a retaliation or a retaliatory measure, the US will end up imposing higher tariffs on Indian imports so as to counterbalance or sort of a punitive measure or a retribution to the fact that according to them, DST, i.e. equalization levy, is being a unilateral levy, does affect or cause this prejudice to the US company. So for the moment, because 2023 seemingly is on the horizon and about 130 countries have agreed in principle to be party to this global minimum tax framework, and as a result thereof, for the time being, both the countries have decided that the imposition or sanction of tariffs or implementation thereof should be kept in abeyance for a little while. I will also take the benefit of the time given available at my command is to take you through some of the recent trends in terms of some judicial controversy, which was certainly on the anvil with the interplay of equalization levy and the Income Tax Act, and the conjecture or the hazard which we were conjecturing that how the courts would finally be thrusted with this again, another piece of avoidable litigation because of unintended good drafting or intentionally ambiguous drafting, or so to say. In fact, I'm reminded of the Honorable Chief Justice of India, who very recently in the Constitution Day celebrations on 26th of May did suggest that quote unquote big issues do overcome if legislative process is not thought through. And there are two classic examples which are currently being seen. One which in Delhi we have just, the third one is just which has happened in Delhi, so to say, and two are currently on the anvil. So what has happened in terms of bad legislative drafting was the issue of reassessment, which Delhi High Court has gracefully seen over, and the matters are now equally pending before some of the other forums, and that was also a case of intentional or unintentional bad legislative drafting. Similarly, you've got two more instances which I was referring to. One which deals with the subject matter of today's deliberation is that how Equalization Levy and the Income Tax Act be read together, considering that both in a way are Siamese twins of the tax disposition, so to say, but at the same time, strictly speaking, Equalization Levy is not part of the Income Tax Act and it is part of the Finance Act. But how the interplay happens, very interesting proposition has been put forth by the revenue in terms of bringing up the principle of apportionment, which I found was very unique and very interesting, so to speak. The other case of bad or intentional ambiguity which persists is again the interplay between the Black Money Act and the Income Tax Act, which is certainly not the subject matter of today's discussion, but again it also highlights the fact that how all these situations ultimately put the taxpayer at a wrath, so to speak, and he has to bear the brunt of it. Anyway, we will discuss the aspect which relates to our discussion on digital business taxation, and I will take you through three decisions. One is the recent decision of Google of Delhi High Court. I'm not talking about the famous Google decision, which has been remanded back by the Karnataka High Court to the tribunal on the ad spend payments and whether it relates or is characterized as royalty or not. Then there's another decision which we will see of Corsia, and the third decision is in the case of Sumo. So these are three very, very recent decisions which we will consider during the course of our deliberation. Very quickly, let's look at the background. Yeah, let's flip and come to the next slide. And for those of us who really want to understand why do we need to tax digital economy. Now, as I fondly do refer that geography will become or has become history in the age of digital economy, where the traditional conventional classical basis of taxation of having a physical presence which gives the right to the source country to tax may not be or is not certainly relevant. So therefore, most of the multinational organizations who are conducting their business with almost zero or nil physical presence can escape tax liability in the case or in situations where the income is principally categorized or classified as business income. And insofar as the e-commerce operators are concerned, many of these e-commerce operators did not file their tax returns, and there was no scheme of or no prescription on taxation which related to withholding of taxes to such e-commerce operators. Even if you go to the provisions of Section 195 of Income Tax Act, which are the governing provisions in terms of relating to the obligation to withhold taxes with regard to payments made to non-residents are concerned. The decisions, and you've had a very elaborate exposition prior to this, eventually the test really ends up, which has been fortified by the Supreme Court in excellence decision affirming the dicta of the Supreme Court in GE, is the fact that whether the payment is chargeable to tax or not. So if I have a business income and I do not have a taxable presence in India, which in the international treaty lexicon is permanent establishment, then you would end up escaping any tax liability in the source state. And therefore this led to a big clamor with many source-based jurisdiction which felt that the conventional scheme of domestic tax law read with treaty is insufficient to deal with such evolving situations of different kinds of business formulations which are mutating by the order of the day in the world of digital economy, so to speak. Next slide. So way back in 2001, if most of you have had a hand in terms of looking at the whole genesis of taxation of e-commerce, it is not something which is new or it's relatable only to the phenomena of the Google, Netflix, and fans. Way back in 2001, following the OECD tag report, a high-part committee was set up by the Central Board of Direct Taxes, and it did submit its report. And I vividly remember going through that report and convening a symposium around it. The report did contemplate a need of introducing taxation. Those of you who have kept pace with the developments in the multilateral forums, especially OECD, would recollect that OECD had a technical advisory group report on, again, e-commerce, popularly known as TAG, Technical Advisory Group report, tag report. And it identified about 17 or 18 kind of transactions for various purposes, and came to certain conclusion as to which transaction should be regarded as what under the OECD model tax framework. And what the HPC report in the Indian context did was to look at all those 17 or 18 kinds of different transactions and analyzed it from an Indian tax perspective, and concluded the tax treatment. Now, the stark difference between the HPC report of the CBDT and the OECD tag report is the fact that the absence of the fee for technical services clause at that particular point in time, or majority of the OECD treaties, model convention based treaties, did not have the FTS clause, so to speak, and any payment which is ordinarily characterized as FTS would be regarded as a business income. Now, largely it was to prevent any source-based taxation in respect of companies which had incomes which could have been characterized as FTS, and that being the principal business of earning such money which is characterized as fee for technical services. And in the absence of an FTS clause, again, by virtue of lack of physical presence, you would have a situation where the entire income ought not have been subject to tax under a classical OECD framework, applying the provisions of Article 7 read with 5 in the absence of an FTS clause. The Indian HPC report was at variance because we have fee for technical services under our scheme of domestic tax law, as well as under the UN model framework, which pretty much is the guiding light of the Indian methodology of sketching tax treaties. Having said so, in my view, India does have its own model. Neither we follow in a purist sense the prescription of the UN model, nor at the same time we are completely influenced by the OECD model. So we have our own way of, we could suggest that there is an own Indian model of constructing tax treaties. Now, if you apply the principle of neutrality, so to speak, just let's take up this last bullet in the previous slide and then move on. Let's go back to slide 5, please. Yeah, if you look at the principles of neutrality, the High Part Committee maintained that the existing laws were sufficient enough to tax e-commerce transaction and no separate regime was required, which I think at that point in time may have done justice to it, but certainly not as time did progress. It was felt that the existing scheme of the Income Tax Act was insufficient to cater with the, as I said, the mutating world of digital economy. Next slide, please. So, before the global minimum tax and the MLI, which are pretty much the new lexicons of international taxation, the concept of MLI evolved from the womb of the entire BEPS project, which was initiated by the OECD / G20, and for the first time, the group of 20 leading nations, including emerging economies like India, Saudi Arabia, Brazil, sat on the same table in terms of being able to participate in decision-making process and not pretty much taking forward the decisions taken by G7 or by, for that matter, by the OECD countries. And in terms of the base erosion and profit shifting, the BEPS project, which led to 16 BEPS prescription. If you look at the first action point dealing with digital economy, pursuant to BEPS Action 1 report on digital economy, and what are the tax challenges posed by the digital economy, what the OECD did through the inclusive framework was to come up with an interim report in 2018, which was under the auspices of Task Force of Digital Economy, TFDE. And since then, as it gained more traction and more wider global participation, almost 130 countries worked on the two-pillar solution, which we will discuss as part of the GLOBE project in terms of figuring out new nexus and profit allocation rules. So, following the Secretariat proposal for the unified approach under Pillar 1, which aims in identifying the basis of reallocation of certain taxing rights to market jurisdiction, and the unified approach in 2020 became the basis of Pillar 1 solution. So why I did bring up the whole aspect of a unified approach here only is for the simple reason that again, the traditional rules of taxation have been found deficient. The traditional rules of international taxation, which we have learned over a period of time, are that there's a source country, there's a country of residence. Now, what is the function of tax treaty? The tax treaty is an instrument agreed upon by two countries, which allocates the taxing rights between the two countries. Tax treaty neither confers the taxing right nor it restricts the taxing right. As a basic jurisprudence on international taxation, one would always remember this, that the function of tax treaty is an agreement between two sovereigns under the whole ecosystem of international law, where two countries sit on the table as two mature adults and would decide a basis of negotiation, and they allocate taxing rights. The country of source and the country of residence will sit together and say that, okay, let's have a treaty in place with our meeting of minds, and basis our ability to negotiate with each other, we will come up with something which both of us agree as a bilateral instrument. The growing emergence of the role of market economies, countries which enable big corporations to earn money from source country, believed that the country of source and the country of residence, in the classical manner, may end up allocating the taxing rights between them, and where the country of residence will tell the country of source that I have not earned anything from you. So even if I apply the treaty principles, or if I do not have any presence in your country, the entire monies which I have earned are at my command and disposal and should be taxed in accordance with laws of my home country, which is country of residence. Now, the third player which did emerge were the market economies, like countries which had high eyeballs and high users in high population. For instance, I am told that WhatsApp, the maximum usage of WhatsApp is courtesy India. About more than 2/3 or 3/4 of WhatsApp users are in India. Now, WhatsApp may, as a part of a big corporation, uh, let's say Meta or Facebook were to own WhatsApp, and because of the high traction which it receives in India, it is able to generate revenue from another third country. And the third country may not have sufficient rules to be able to tax that. Or in the alternate, the market economy like India would say that, well, your ability to earn income is because of users in my country. So for the first time, the entire unified project approach re-alters or has re-sketched the rules of allocation of taxing rights amongst not two countries, country of source and residence. Now we have a third country, which is the country of market, that you earn because of us. You may be earning from a source country, you may be a resident of the third country, but don't omit us in the grand scheme of your allocation of taxing rights. That is the genesis of the entire unified approach and the GLOBE project, which started in 2019 October, when OECD came up with Pillar 1, Pillar 2. That initiative in 2019 of OECD went into a limbo because US had not given its buy-in. US has still not given its buy-in on multilateral instrument project, because US has its own way of looking at the whole world, and it's only when the new administration, the Biden administration, came and they realized that something has been jammed up because of the outlook of the previous Trump administration. They started participating and gave traction to the whole thing, which gave confidence to the world at large that with US buy-in, we all can agree on something, because US and US corporations are a big stakeholder in decision making. Taking or making a decision in the absence of US corporations may render the decision ineffective, because US will have its own tax treatment, and willingly the whole world will have to agree or fall in line with that particular tax treatment. And even if the remaining other countries, the large big economies, would have agreed on a prescription, if it did not match up with the outlook of US, then you may have two different situations. So now US agreeing to this whole concept of allocating of taxation amongst three players, source, market, and residence, has agreed on a framework which by 2023 the whole world assumingly have to agree, and this will give birth to another form of multilateralism apart from the most recent one which we have seen, is the MLI, which was Action Point 16, emerging from the womb of BEPS, and now the treaties have to be read along with multilateral instruments. So hopefully we might have multilateral instrument 2.0, which will help in translating the principles of GLOBE and unified approach shortly as the time progresses. Yeah, next slide, please. So up way back in 2001, we had the HPC report, which gave certain prescription. I wish at that particular point in time some guidance would have come forward from CBDT in terms of characterization issues, but it never happened. 2012 was the big bang year in terms of controversial and contentious amendments in Income Tax Act. We had amendments in Section 9, both dealing with characterization issues and transfer of taxation of indirect transfer of assets. One was rolled back very recently in the month of August only, in respect of transactions done up till 27th of May 2012. I'm talking the Vodafone amendment. And the other amendment was with regard to the characterizations issues on royalties, etc., on which you've had the recent Supreme Court decision of excellence, which again is a contentious decision. Many purists and tax academicians have casted their doubts on the decision dispensed by the Supreme Court, authored by a very famous jurist of the country, Justice Nariman. That also decision does suggest the fact that even with the amendments in the Act, certain transactions which were being characterized as royalty ought not have been done. Of course, I have my own view on this, that if it was not something which was akin to a tangible product, because a lot of emphasis in the decision was with regard to the package software in a tangible mechanism as a CD, so to speak, assuming that it was intangible or not akin to a tangible presence, or a wrapped or a shrink wrapped software, would the answer of the Supreme Court would have been any different, so to speak. Anyway, coming back to the Committee of Taxation on E-commerce in 2016, 15 years later, did submit its report. It's a very well readable document, so to speak, and I would recommend each one of you who intends to work upon the nuances of digital business taxation must go through this particular document, so to speak. It has been, this document is the basis of introduction in many ways of the equalization levy, which was introduced in 2016 by Finance Act, as I said, by virtue of introduction of Chapter 8 in the Finance Act. And this document is also in the backdrop of OECD BEPS Action Plan 1, which deals with the tax challenges of digital economy and considers the three options which were placed for considerations of various economies by OECD, that either you could expand your source base, so have something known as significant economic presence, or impose equalization levy, which is digital services tax, DST, keep it out of the purview of the Income Tax Act and the nature of tax not really being an income tax act. Now you would argue that is it an indirect tax, so to speak. The third is look at situations of expanding your basis of withholding. So these were three alternatives which were suggested in BEPS 1, extensively or elaborately dealt with and considered in the OECD, in the CBDT's E-commerce Taxation Committee 2016 report, and EL was considered as an efficacious alternate. Yeah, next slide, please. Yeah, next slide, please. So this is how, under the chairmanship of the noted tax bureaucrat earlier, Mr. Akhilesh Ranjan, a report was furnished in 2016 February, and the enforcement happened in 2016. And then under the GST regime, we had the introduction of online information database access retrieval services, which is OIDAR. And in 2018, SCP was introduced. In 2020, the Equalization Levy 2.0 was introduced, and amendments were made to the ACP provisions which were earlier introduced in 2018 by virtue of introduction of Explanation 2 capital A. And then in 2021, we had again some clarifications to the regime of Equalization Levy 2.0. And then we also saw the insertion of Explanation 3A to the provisions of significant economic presence, which were introduced in 2018, never got effectuated, having got legislated. Then 2A came into being, and then 3A came into being. So this is how our unilateral domestic tax laws have evolved over a period of time. What will happen in 2022-23? Will we have another MLI, or will there be some corresponding amendments made again in the domestic tax law? Well, one stark question which pretty much is in the eye of the entire tax policy consideration, which we will probably ponder over in the latter part of the deliberation, is the fact that having gained so much of traction on collection of equalization levy, so to speak, and now the fact that the country earns significant amount of revenues on equalization levy, and it is expected that software as a service, SaaS, India could end up making about $75 billion by 2025, so to speak. And therefore, would India, as it has been suggested, that once the global minimum tax framework in 23-24 does see the light of the day, will India end up giving up on equalization levy, which most of you would understand in terms of taking a clue from various kinds of charges and cesses and taxes which were introduced as a stopgap or a short gap arrangement, have never been per se withdrawn, whether these are higher secondary cesses or secondary cesses or so on and so forth. So point is very simple. I mean, having introduced a tax, it is seldom that you find India rolling back. So assuming that there are great amounts of collections which are being done from equalization levy, will India end up withdrawing the equalization levy? Just to give you a sense, in financial year 21, the EL saw collection touching about 2000 odd crores, so to speak. And on a year-to-year growth, this was 81% incremental rise when you compare it with the figures of the previous year. Bangalore clocked up about 1000 odd crores, Hyderabad about 530 odd crores, Delhi about 320, and the remaining came from just about 130 crores from Mumbai. So having seen a meteoric increase of over 81% on a year-to-year, when you saw about 2000, when you see about 2000 crores as compared to 1000 crores, compare figure of 2020 with 2021, with nearly doubling of the collection, would it be I mean, you need a real great leap of faith to sort of withdraw it. Let's take a 2-minute break, and then we'll move on and look at some nuts and bolts of equalization levy. Just let's take a 2-minute break by the clock.
Okay, sir.
Okay, let's proceed and let's look at the substantive aspect of the provisions of EL with this background and discussing the entire framework in terms of the edifice of it. Yeah, next slide, please. So in 2016, we had the famous introduction of equalization levy, and in the backdrop of the decision of right florist of the Calcutta bench of the Honorable Tribunal, where certain payments were made which were towards advertisement, banner related payments on hosting of websites, and the tribunal did emphasize the fact that these payments do characterize as business income, and in the absence of any place of business, these do not qualify for taxation under the Indian tax regime, under the scheme of the taxation read with treaty, so to speak. And therefore, it was introduced primarily on provision of advertisement space and other related services, and it 6% was the rate, so to speak, and that was the benign introduction of finance EL in Finance Act 2016, which reminds me of the introduction of service tax in 1994 with only few categories of service, and over a period of time, service tax ended up being a larger contributory to the kitty of indirect taxation. And uh, uh, if the entire world is going to go the digital way, I mean, you never know, this 2000 crores may end up being what in times to come. In 2020, EL was levied at the rate of 2% on another category or another nature of payments, which were payments in the nature of consideration received by e-commerce operator and for e-commerce supply or services which were provided or facilitated, and they came into being in 2020. So you had the 6% thing, and now for e-commerce services and supplies you have EL 2.0, which talks of 2%. Now this is where the challenge does start, and where the challenge starts is if you look at the second bullet of this parallel grid of Finance Act 2020, which says corresponding amendment made in section 1050 of the Income Tax Act, right? Now moving forward, now what happened in 2021, the last budget which we had. Next slide, please. Yes. So the scope of transaction qualifying as e-commerce supply or services were enlarged. The term online and online provisions have been now deemed to include one or more of the following online activities. Remember, it's a deeming provision to include one or more. So it's not a cumulative test. It says acceptance for offer for sale, or placing an purchase order, or acceptance of the purchase order, or payment of consideration, or supply of provision of goods or services partly or wholly. So therefore, ex facie, undertaking any one or more, it's not saying all, any one or more of the activities described in the points above could result in an online sale of goods or online provision of services, having regard to the enlarged definition introduced or inserted by Finance Act 2021. So what if I go to a showroom, look at a particular product, come back, place an offer on the portal, go to the showroom, pick it up? Will this be constituted as an online sale of goods? Just disregard for a moment whether I do qualify as an e-commerce operator or not, or an e-commerce supplier. for a moment, let's disregard. Let's just focus on the fact that what would constitute online sale of goods or online provision of service. I make a call, some guys of Urban Clap come to my home, they render service. I pay on cash, service on delivery, but the initial job order was placed over the portal. So will it still qualify as online provision of service? So these are few challenges. This is one great challenge out of those few challenges as to what will in strict sense be termed as online sale of goods. Is online sale of goods the way I see it, or with this deeming provision the entire definition gets so fuzzy that any criteria being ticked will eventually result it in being characterized as online sale of goods or online provision of service. So that's one part of it. The second part of it was the clarification, which is the last but one bullet, the penultimate bullet of this slide, just to help you, is whether an e-commerce operator owns the particular platform. That irrespective of the fact that whether e-commerce operator owns the goods, provides online services, to said online services, the consideration shall include the consideration as per the mentioned clarification. I do not own, I just provide a marketplace. I don't sell those goods, but I receive it at the big, by virtue of the payment protocol or the given gateway as the first port of call. The monies do come to me, but I will retain only a wafer thin margin and then pass it on. So the clarification says irrespective of the fact that whether you own it or not, the consideration will be treated. I can't make a case of an abatement or so that I will only get 2 rupees. The 100 paid by the user or the buyer, 98 will go back to the person who had hosted the goods on my portal. My job was only to get 2 rupees. The 100 which I get pursuant to the payment gateway protocol, I should be only foisted with a liability of on whatever I'm going to earn, which is 2 rupees. 98 I'm going to pass it on to him. So this particular provision, so-called clarification, doesn't buy that particular argument of the abatement or the fact that why it should not be only on 2 and why it rather it says you receiving 100 is the consideration. The third, the anomaly which the government removed is through the corresponding amendment in 1050 of the Income Tax Act. Now remember, EL is not part of the Income Tax Act, but part of the larger income tax statute framework pursuant to Introduction in Finance Act, agreed and discussed umpteen number of times. But if a transaction has been a subject matter of EL, then for income tax purposes, it will be regarded as an exempt transaction, and 1050 makes it very clear. Now, since certain categories of payments were introduced by Finance Act 2020, the question was the corresponding amendment in 1015 also, which didn't mention 1st April 2020, so to speak. So in 2021, they said that, okay, let's not create a situation where there is a gap for 1 year. In 2021, they said that EL 2.0, which was introduced, right, 1050 will also take effect retrospectively from 1st April 2020. So thus all transactions on which EL was introduced is exempt from any kind of charge of Income Tax Act. Now this is the concept is fine, but the sheer fact that you are suggesting that anything on which EL is foisted will not be a subject matter of Income Tax Act is fine, and you don't want a double levy or a double exposure, so to speak. But who is going to decide? Is there a sequence? Is there a prescription? Or it is completely dependent upon whims and fancies of the revenue? We acknowledge there is an overlap. We gave out an exemption provision in terms of introduction of section 1050. We even clarify that 1050 will relate back to 2020 because of the gap, so to speak. But who is going to decide what falls where? And this is what we were apprehending has seen the light of the day, with matters now getting escalated to the courts. Next slide, please. So let's take one case study just to sort of break the momentum, monotony, so to speak. You have ACO, which is a pharma company incorporated outside India in country A, which operates a website to provide information about its company, and it displays its products online. Situation A, Mr. Z, a person resident in India, after browsing through the website, sends an email, places an order. ACO provides the order confirmation. ACO provides the order confirmation to Mr. Z, who is an Indian, and sends an invoice over email. Mr. Z makes a payment for product online. ACO physically dispatches the products to Mr. Z in India. So there's a physical dispatch of product to the address in India. Situation B, Mr. X is a non-resident. He visits India on a business trip. While in India, Mr. X places an order on ACO's website. If I'm in India, I'm assuming that you're using an IP protocol which is Indian, and makes a payment online. ACO, being a foreign company or a company incorporated outside India in country A, delivers the product at Mr. X's address also in country A, because Mr. X and ACO are both hailing from country A. Yeah. Now let us look at some simple prognosis. Next slide, please. Now, even if one were to say in situation A that ACO qualifies as an e-commerce operator, now the consummation of sale happened through physical delivery in India. Now, whether such physical delivery would also result in online sale, as we just saw the 4 bullet points which were introduced in terms of a deeming clarification in 2021. Now, situation B, if X is a non-resident and he places an order while he's in India, now the goods are meant to be consumed in the foreign country where X is residing, where A is also hailing from. Still, EL provisions ought to have been or should have been levied, considering the spirit of the fact that the consumption is also happening outside India. The country where the goods are going to be delivered and the company they hail, the consumer, the producer, so to speak, or the supplier, if you don't want to use the word producer, the supplier, the recipient, both are outside India. But he happens to place an order while he's in India on a business trip, considering that he's not a resident of India. He came here for a little while, found something interesting while he was here, ordered it. Admittedly, he and the company both hail and belong to a place outside India. So any thoughts of the attendees here on situation A and situation B in terms of this case study? More than happy to take views. Any thoughts of the audience? Do we have any views from any of the attendees, please, here?
So
Anybody
let
who
me
would
check,
like
sir.
to?
Actually, yeah, they can't unmute themselves since it is a webinar. They might put up the
Anybody?
views in.
Yeah, anybody who raises a hand and is willing to make a point or two.
Yeah, let me just check. So if there's any, I'll read it out. So they can put it in chat box. I'll just compile it. Okay. In the meanwhile, we'll continue. If there is any, we'll check.
Okay. So let us take another case study. Here, ABC Inc. is a foreign company which is engaged in business of selling air conditioners. It accepts the orders via email and sells the products through its website. PQR is another company, another foreign company which has a platform which is managed and operated by XYZ, for which XYZ pays a fixed fee to PQR. Now, XYZ Inc. has its own branded goods which it sells through online portal, and third-party sellers can also sell their goods through the portal. Situation A, customer A resident in India places order with XYZ via email or places orders on the website of ABC Inc. to purchase ACs. Goods are physically delivered by ABC Inc. Payment is made directly by the customer to ABC Inc. Scenario 2. Next slide, please. Customer B, who is resident in India, places an order on the portal to purchase the ACs from ABC Inc. As per the terms of the portal, the sale consideration is between ABC Inc. and Mr. B, and portal is just a facilitator. Mr. B makes payment to the portal, which pays to ABC after deducting its commission. Let us look at another scenario, scenario 3. Customer C here is resident in India, places an order on the portal to purchase goods from XYZ. As per the portal, the goods shall be transferred and along with the risk and reward once they are handed over. C makes payment to the portal and the commission is retained by XYZ and the remaining payment is made to the seller. So in all these three scenarios, do we have some views of the attendees here, please? Why these different iterations have been provided out to you is just to the fact to illustrate or elucidate that what conventionally we believe in terms of the first principles of law, in terms of service, sale, contract, the classical principles of consummation of a transaction, delivery, fructification, etc., may not hold good in the deeming provisions and in this artificial linguistic world of equalization levy. You have to read the law as it is, and unfortunately the basic golden adage principles of Sales of Goods Act or the Indian Contract Act may not bear you out in terms of the levy. It's a different matter that uh, courts may end up taking a view applying these principles, which uh, may happen if somebody is going to contest them. But the point which I'm trying to make home is the fact that the deeming provisions with regard to e-commerce supply or service are such in nature that they may sound inequitable when you apply the classical principles of contract, agreement, supply, consummation, etc. So what you have to consider when you look at equalization levy is the fact that to whom the services are being rendered. EL envisions a situation to whom ultimately services are being rendered. So that's first point. And here you should rely or take into consideration a famous old CSTAT decision rendered in the service tax dispensation of Paul Merchant, uh, which suggested the fact that when it comes to service, you have to consider to whom the services are being rendered. Next point, as a proposition for EL, is the privity. You have to see the privity amongst the parties. Mere interaction with customer may not be enough. The e-commerce operator should also be rendering some service, and interaction may all by itself, the interaction may not all by itself yield rendition of service. Now, you can argue with me. Yes, yes, please.
Sorry to interrupt you, sir. Just one quick clarification. Scenario one, I think, may not be applicable because it's through an email, and there is no portal in place to make an order, and
Right.
we are covered. We are outside the purview of equalization levy because email is general correspondence which between parties which can happen, and there cannot be an scenario where you try to impose equalization levy on that. So that's my view on scenario one. One doubt, scenario 2 and 3 seems to be overlapping, because both they in both the scenarios, I think there is an e-commerce portal, but the only difference is scenario 2, he only acts as a facilitator, but given the language in the law, I don't think so. Just being a facilitator also may not be, you may still be categorized as an e-commerce operator. So that's my own humble view, but probably you can correct me if I'm wrong, because scenario 2 and 3, that's the only difference I could see.
Yeah. So thank you at least for making this enthusiastic response. Now, on the aspect of rendition of service, you should also not lose sight of the decision of Supreme Court in Kotak Securities, 383 ITR Supreme Court, where they said that fully automated facility may not be service. Provision of facility should be in the nature of service. If I can prove that my process is so AI driven, or you can use a different expression to suggest the fact that it is completely automated or digital, say to speak, and there is no human intervention involved. Where is the question of my rendering any service as such? And then on the aspect of when the charge is created, I will again beseech the audience here to go back to that famous old decision of Gobind Saran Ganga Saran, 155 ITR Supreme Court, where 4 aspects in terms of what constitutes a charge, right? All these aspects must be present for a charge to get fructified. Now, a few more propositions for you if you are revisiting or looking at the EL provisions. It might just help you. First and foremost, can you argue that 163 also has a semblance of a charging section? Please take note of it. Can you argue that 163 has a semblance of a charging section, though 165 and 165 capital A are being designated as charging section? So as a result of this, is it fair to say, as a proposition, is it fair to say that whether something is not getting covered or exempt under 165, whether gets covered in the ambit of the larger section, charging section of 165 capital A? If it is not getting covered in 165, whether it's getting covered in 165A? And then at certain places in the EL scheme, it's not a very elegant piece of drafting. I mean, and none of the recent legislative pieces of drafting are so elegant. But is there a precise reason or a deliberate reason where at some places you have used the word for, and at some places you have used the word from, and will it make any difference? For instance, 165A uses the word from, and 165 subsection 3 uses the word for. So is it a deliberate usage, a distinctive deliberated usage, or these are interchangeable. So if you look at the overall scheme of drafting, it's not very elegantly drafted, as I said. One should not pay much attention to do the hair splitting that, or at some places for is used and some places from is used. It might be just a manner of manifestation of some contextual interpretation. Now, in case of abatement, uh, whether abatement can be envisioned in certain circumstances where the end supplier or service provider is an Indian resident and facilitator is just a non-resident front-ending the transaction. How will you look at the proviso to 163 subsection 3 when you read it with explanation to section 1050? Now, is there a difference between an act of advertisement and sale of advertisement? Sale of advertisement we saw EL1, isn't it? Now, whether a sale of advertisement uh, is different from an act of advertisement. And similarly is the question of sale of data. Now, data is also referred in 916, and I will come to this the present conundrum which the courts are facing with regard to, as I said, what should be the scheme? Are you going to look at EL, or are you going to look at the FTS royalty provisions first? And because 1050 says whatever is not included, 1050 categorically suggests the fact that you have to, is the reading of 1050 suggestive of the fact that first you have to see whether it is royalty or FTS, and if it is not royalty on FTS, then you come to EL. And insofar as sale of data is concerned, I would also suggest that the red herring is to compare the provisions of SCP also with the EL and read it along with 916. The real controversy is what is the scheme you are going to apply. Are you going to first exhaust the principle? Are you going to first exhaust the application of the domestic tax law and then come to EL? Or you would take a pragmatic thought and say, well, EL is 2%, the conventional rates of withholding are 10%, so let me opt in for EL, provided I meet the other criteria, and I will not opt in for the provisions of withholding under the provisions of 916 or 917, so to say, and we'll come to that. Now, what do you mean by the word data collected also? And where the liability is abated under 1050, is EL applicable? Whether you can argue, or let's say a situation where a treaty benefit was available but is not available, either on account of principal purpose test or on account of any other provisions of MLI read with treaty, and will now you would make a case that, well, it does not qualify and therefore EL will be applicable. So there are a lot of questions in and around this. Let us move forward, please. Next slide. These are compliance oriented timelines, so we can just quickly rush them through. Let's take the next slide with regard to levy of interest and penalty. Yeah, next slide, please. Next slide. Yeah, now let us come to another component of taxation of digital economy, which deals with section 194. My apologies, it is written 94O. This one is missing. Please read this as 194O. My sincere apologies for this. So it says, notwithstanding anything to contrary under any other provisions of Part B of Chapter 7 of the Act. It says where the goods or provision of service of an e-commerce participant is facilitated by an operator Such operator shall at the time of credit or payment to such e-commerce participant shall deduct tax at the rate of 1%. Now, who's an operator? He could be either a resident or a non-resident, but a ECP, a participant, is a resident in India. You remember this fact. Operator could be a resident or a non-resident, but if he is making payment to a participant who is a resident in India for selling goods or providing services or both, right? The threshold of no withholding in case of individuals or HUF, where their income, where the gross, not income, where the gross amount of such services rendered during the previous year or sale is up to 5 lakhs of rupees, provided you give your PAN or Aadhaar to ECO. Yeah, next slide, please. So this is a small slide which just explains the differences in terms of involvement of section 194.0, right? Now you have those TDS compliances applicable if the gross amount of sale exceeds 5 lakhs of rupees, and whether PAN or Aadhaar is provided, and if it is not provided, then 206AA will come into picture. Yeah, let's look at a circular number 17, which is there in the next slide. Next slide, please. So 194.0 is not applicable in the following situation, and then the circular also clarifies that if tax has been deducted on 194.0, and then you will not be required to deduct tax on the same transaction, and you could take an undertaking where there are third-party gateways which suggest the fact that same income is being subject to TDS on more than one occasion. Insurance agent and aggregator who has no involvement would not be liable to 194.0. For calculation of 5 lakhs of rupees, the year has to be counted from 1st of April. Yeah. Next slide, please. Yeah, this is the rationale, which is quite self-explanatory. We can skip this. And then what are the exclusions which we have just seen? Next slide, please. If the ECP does not furnish his PAN or Aadhaar, then TDS must be deducted at 5 instead of 1% as per 206AA, which I had highlighted a little earlier. Yeah. Before we move on to SCP, let us look at some few judgments which I have been alluding on more than one occasion, right? And here I would request if we can straight away move to slide 32, please. Yeah, slide 32. Yeah. Now this is the conundrum which I have been referring on more than one occasion. This is the judgment, just a little small paraphrasing of the judgment or the interim order pronounced by the High Court pursuant to a writ petition preferred by a non-resident company whose name is Sumo Logic. The date of the order is 23rd of August 2021, and now the matter is listed in somewhere in the month of March. Right? This was a writ petition which was filed challenging the order under 264. A petitioner's request was made where a petitioner was 197 lower withholding tax was issued, whereby the Indian tax authorities pursuant to a 197 withholding tax certificate suggested that the customers should make payment at 10%. Now the US company challenged the certificate, suggesting the fact that it is the case where the application of EL was being rejected, and the petitioner being an e-commerce operator for the purpose of section 164, it did not have any permanent establishment in India, and all that it was doing was providing subscription-based interactive website access for online data analytics for the Indian customer. So according to the petitioners, they sought a directions to issue a certificate permitting TDS at nil rate. Now, these are the two questions which have been posed. Now, the matter is listed for hearing in the month of March. So this is one decision in the case of Sumo Logic. The other decision is a very interesting decision, interesting for the arguments which the revenue is trying to take. And this decision is in the case of Coursera. Coursera is a decision, again a date, it's very recent. The date of the order is as recent as 22nd of December. Again, a writ was preferred before the Delhi High Court against a 197 lower withholding certificate, which was sought by this US non-resident company. According to the US non-resident company, they are in the business of aggregating educational institutions and provide access to various courses, and a certificate is given which is awarded to the student. So maybe it's an aggregator, provides a platform for various educational institutions to come on that particular platform. It aggregates all of them. Students are provided the course completion certificate from the particular university, and their job is merely to aggregate or to facilitate. Now, they had applied for a nil withholding and they got a certificate at the rate of 10%. Now, the interesting argument in this case is from the revenue. Revenue says that, well, you'll read 1050, and the way it is read, and let me read 1050 for you if it is not handy. It says any income arising from specified service or provided on after the date on which provisions of Chapter 8 of Finance Act 2016 comes into force. And then the explanation one which has been inserted: for removal of doubts, it is hereby clarified that income referred to in this clause shall not include and shall deem to have never been included any income which is in the nature of royalty or FTS under the Act, read with agreement notified by central government under Section 90. I mean, royalty or FTS read in Act along with treaty. So the revenue says the way 1050 has been carved in or incorporated, that the concept of apportionment of receipt has been introduced. According to revenue, out of the total amount of receipt of petitioner, the amount characterized as royalty or fee for technical services will be chargeable to tax under the Act, read with treaty as royalty, and the balance, if any, will be chargeable to tax under as equalization levy. This is a very novel argument which they are trying to put forth. Then now you apply principle of apportionment. You take the entire bucket, see what is royalty, and the ones which are which qualify as royalty as per the characterization under the Act, read with treaty, 195 will apply, and for the remaining part, if any, equalization levy would be provided. Now the High Court while this certificate of 197 was impugned, according to the High Court, the petitioner has been directed to withhold tax at the rate of 10% pursuant to the application, although no reasoning has been provided. In fact, the withholding tax order says that since the assessee has suo motu paid equalization levy of 2% and has filed of equalization levy challan, and such receipt may be subject to TDS under 195, keeping in the interest of revenue, the recommendation is made to ask them to pay more. So, according to the High Court, the petitioner in its application did suggest the fact that it is an e-commerce platform operator, and it is also entitled to claim the benefits of Article 12 of the DTA between India and US. Of course, the 197 order does not take care of all this, and the High Court, pursuant to the writ petition, did set aside the 197 order and asked the tax authorities to pass a reasoned order after taking into amendments in terms of provisions of section 1050. So this has thrown cat amongst the pigeons in terms of how will you decide, or who is going to decide, and what is the talisman of your decision making. What are those grand norms which you will keep in mind, considering that there is possibly an overlap, considering the fact that it might qualify the various prerequisites of chapter 8 of EL, and at the same time taking the pragmatic thought into consideration, 2% versus 10%, and electing the provisions of EL, assuming the prerequisites of EL are met. All of you would remember the vexed issue of MasterCard, where MasterCard was foisted with a negative AAR, and later on the provisions of EL were also thrusted upon MasterCard, and MasterCard went to Delhi High Court and said that, well, on one hand you are telling us through our negative AAR ruling that we possibly have a presence in India. If we have a presence in India, then why you are asking us to pay EL? So the High Court gave them that protection that till the time we decide the matter, because you've come up before us challenging the AAR ruling, if we hold that you have a P in India, then of course admittedly EL will not be applicable. So to that extent they have kept the provisions of EL in abeyance. So this was the case of Sumo Logic. Now let us go back and spend a little more time in understanding the next segment of today's deliberation, which is SCP, please. So let us come back to slide number 26, please. 26, yeah. So if you look at the Finance Bill 2018, what the memorandum explaining the Finance Bill does is to quote Leagues of Nations literature, which was dispensed somewhere around almost 100 years ago. And a very interesting paragraph was cited out of that literature, suggesting the fact that the value addition has to be shared by different authorities, by different jurisdictions. And according to the justification given in the Finance Bill 2018, again relying on BEPS action plan 1 of tax challenges of digital economy, the Finance Bill makes it very clear that a new nexus rule based on SCP is required, which helps the country in ensuring a situation where a purposeful and a sustained interaction with an economy with the aid of technology is brought in within the ambit of source rule, and a given revenue factor or a combination of other factors should be taken into consideration in terms of determining the economic presence. First and foremost, the source rule must be expanded because the existing nexus rule, which was used as a proxy, doesn't help in the case of digital economy. Having identified then what should be the factors which determine that there is a significant economic presence, some mathematics, some algorithm, some yardstick, some threshold must also be provided. These are the highlights of the basis or the rationale of introduction of SCP in 2018, which came but didn't, having got legislated, did not got effectuated up until recently. So let us look at the scope of SCP. Let's jump a slide in between and come to slide 28. Yeah, next slide. This is important. 2A. It said that following transaction would constitute an SCP regardless of the fact that agreement of such transaction is entered in India, they have a place of business in India, or services are rendered in India. So there is some background noise coming.
Just check, sir. Somebody else unmuted or something.
Yeah, can you mute?
Yeah, I muted everyone. So I muted them. Can please.
Though the SAP provisions were meant to take effect from 1st April 2019, however, the lack of clarity or an international consensus as to what should be that mathematical magical number which will trigger that SCP, there was a lack of doubt on that, and therefore the provisions were deferred to assessment year 22-23, and it was suggested that it shall take effect from 1st April 2022. Although a notification, public comments were invited with regard to what should be the threshold or the revenue. And all of you do remember the fact that in 2018, some notification was issued in terms of seeking public comment. As recent as 3rd of May only, last year, 11 UD was introduced in the rule book, which suggested the following threshold. A, 3 lakhs should be the number of user, and 2 crores, INR 2 crores should be the value. And if these two categories are met, then it would yield a significant economic presence. The aforesaid thresholds would take effect from 1st April 2022 and therefore would effectively apply for assessment year 22-23. My paper on this is very elaborate and deals with various nuances of it. In the interest of time, if you find this discussion a little hurried, I would urge you to look at the paper. Now let's consider the explanation 2A with explanation 3A, and then we will come to rule 11, which was the new rule which has been introduced by notification number 41 of May 3rd, 2021. Yeah, next slide, please. So this is the difference, and the highlighted ones between red and green are the important differences. Explanation 2A, the old one, was clarificatory. Now it is declaratory. So that means it meant as if it was actually as if this was the actual declaration, right? In clause A, the stark differentiation is earlier the phraseology was non-resident in India. Now the scope has been expanded. It says non-resident with any person in India. With any person in India. So that expands the scope. If you go to clause B, instead of the phrase users in India through digital means has been done away with, and which is the bane of contention now, that the aim and purpose in terms of BEPS action plan 1 was to look at digital economy. Now this pretty much will affect any brick and mortar or a conventional old economy kind of business also, which the revenue has gone, in my view, in clarifying that, well, if that happens, then so be it. In other words, the taxation intention is not only for digital economy, anything which qualifies as a significant economic presence, regardless of being a digital economy or otherwise. So that has the through digital means, if you see in clause B, as there in explanation 2A earlier, has been conveniently given a go by. Now let us look at the notification number 41. Next slide, please. Yeah, next slide. Yeah, the CBDT on wide notification 41 has come up with no, go back please. Yes, so you have a revenue link consideration and the user link consideration. So revenue link consideration is a revenue threshold of 2 crores And user link consideration, if you are looking at, is 3 lakhs of users. These threshold, as I said, are applicable from 1st April 2022. Now, by notifying the thresholds and putting the numbers into place and clarifying that by when these are coming into picture, now you can easily say the SCP provisions are in effect. Of course, as I said earlier at the beginning of the deliberation, the the utilitarian poser insofar as treaty related scenarios are concerned, that until and unless the treaties are amended, you would apply the beneficial provisions of treaty read with circular 333, and these provisions, although are in act, may be academic. But again, the question comes with MLI in picture, and you have the principal purpose test in and GAR also in section 90. What happens if the refuge or the umbrella of treaty is not there in place? Then you are exposed to a bigger catchment in terms of an expansive source-based prescription, and therefore you should be mindful of the fact that even though they are legislated and effectuated, not each and every situation, even in a treaty context, would make them inapplicable or academic. I mean, to put it in simple words, even now you find revenue pursuing the old unamended Indo-Mauritian tax treaty beneficial provisions which are being availed. So the temptation of revenue even in the pre-GAR regime was to disentitle treaty benefits for one reason or the other. So therefore, to say that, well, I am coming from a treaty, so I don't need to look at 2A, 3A, doesn't really help. You should be mindful of it, and at the same time equally cognizant of the fact that all the prerequisites which would enable you to claim treaty benefits are certainly put in place, so that the challenges or of non-availment of treaty situations are kept at bay, and you are avoided from the rigors of the wider bandwidth of catchments of source-based taxation. Next slide is something which I have discussed partly, but no harm in going through this another time. So the first bullet we've already considered. If EL is levied on a transaction, in such a case the income attributable ought not be taxed under the scheme of the Act. Now, the proviso to 163, which we discussed a little while ago, it clearly says that the consideration shall not include such consideration which is taxable under royalty or FTS, which is a corollary to 1050, which we just saw, and only such amounts which get excluded, which is taxable as royalty or fee for technical services, in case consideration is not taxable under the Act, even though it is characterized as royalty or FTS, either due to provisions of the Act or due to beneficial provisions of treaty, the same is likely to be a subject matter of EL. Now, this is the last category, is a gray zone. If something which is not taxed as royalty or fee for technical services under the Act, and it qualifies the criteria of EL application, then one can argue that, well, it is not covered to begin with, and it is not something which was taxable as royalty or FTS. So therefore, EL is spared. Here you will argue that, well, it is neither royalty nor FTS under the Act read with treaty, so therefore EL is not spared. So this is the gray zone, which is where EL might just spring up. Although one may argue and say, well, it's not taxable under FTS or royalty, so the scope or the exposure of taxation ends, and it doesn't trickle down to the world of EL. This might result a situation, although within the mainframe of treaty read with Act, the incidence is mitigated, and that's the end of the matter. We put things to a rest, but that's not going to happen. EL might just surface, and you should be mindful of this particular fact. Let's move forward. The sumo logic we have just considered, so we could skip this and come to the decision of US Supreme Court of South Dakota versus Wayfair. Now, till very recently, US did champion the cause of physical presence. Now, this is a judgment rendered in the context of sales tax. We all are aware that US does not have a sophisticated GST regime. It still has the conventional sales tax thing. Now, US all along has championed the cause of having articulated the importance of physical presence in terms of a nexus. And in 1992, you had the famous Quill case, Quill Corp versus North Dakota. Now, in Quill, it was recognized that sales which were otherwise subject where only vendor had a physical presence. But South Dakota versus Wayfair took a complete U-turn, and the Supreme Court said that physical presence is no more relevant. Modern e-commerce does not align with the test of physical presence, and it revisited and decided that in the given substantial technological changes, the decision of Quill has become outdated. So there was a minority view and a majority dissenting view on this, and both the views are given in the next slide, please. So I would urge you to read this decision of South Dakota versus Wayfair, which highlights the paradigm shift both with the law enforcement agencies, which we have seen, the legislature in terms of drafting new laws, which we have seen with introduction of ELSCP, and with the judiciary also recognizing that the traditional rules of the game may not be sufficient, as they have said that the ruling articulated in Quill has become outdated. The court observed that the changing rules to one requiring state to collect and remit sales tax to states where vendor does not have a physical presence nexus would pose burden on small businesses. But the majority and the dissent made a very different assessment. According to the majority, taking the position that today's interstate technological environment itself provided a sufficient nexus to impose sales tax compliance regardless of a out of state vendor physical presence nexus. Go back to the amendments made in section 9 and 195 pursuant to the Vodafone decision. Vodafone in 2012 said NR to NR, no 195. That is what the concurring judgment of Justice K.S. Radhakrishnan was. If you remember Vodafone, we had two decisions. One given by Chief Justice Kapadia, and one was a concurring decision by the third judge K.S. Radhakrishnan, who clearly said that in case of payments being made to one NR by another NR, the question of withholding tax obligations under the scheme of the Act does not arise. To overcome that, 195 and 9 were again amended, right? And this is exactly what the majority and the dissenting view said, that insofar as compliances are concerned, the technological environment itself provided a nexus. Right? Next slide, please. With this, we come to the last segment, which is the global minimum tax globe. And let's look at model 2 to begin with, and we'll also look at a little shades of model 1 and complete both the things. Very quickly, model 2 says that minimum effective taxation of 15% in cases of those multinational groups where revenues exceed 750 million euro. This is the same threshold for CBCR also, where you are looking at the revenue threshold of 750 million. So pillar 2 aims to discourage competition, and it says that, well, 15% should be the global benchmark rate amongst all countries, and this will help in eliminating tax competition, and it will rather promote the cause of healthy tax competition, so to speak. Yeah, next slide, please. So all these big corporations which will be eligible for GloBE will have to provide with some kind of information required under the model rules to assess their tax liability. There are certain carves out in terms of corporate restructuring and tax neutrality situations which will not be part of GloBE, and aspects of things like tax deductible dividend regime or tax transparent regimes, etc., have also been considered. Now coming to pillar 1. Next slide, please. Yes, pillar 1 talks of a situation where you have the entitlement of a fair tax to the market economies, which we just saw. So if pillar 1 is adapted, then DST unilateral levies, including EL by India, will have to be withdrawn. So you have amount A, amount B, and amount C, which have been identified in pillar 1, and which will enable the market economy to get a fair share pursuant to the formula of adapting given in terms of calculating amount A and amount B. How this historical development happened, if you are looking to understand the genesis of pillar 1 and pillar 2, as I say, it all started in 2019 and then moved on. Slide 39, please. Yeah. So 2019 plan was made, and then by December 20th, OECD released the GloBE rules of pillar 2, which was very recent, which had the concept of income inclusion rule and under tax payment rule, right? And on October 8th, 136 countries, including India, reached an agreement of agreeing to a 15% minimum tax on multinational enterprises. Then how would you compute these amounts? There is a very helpful slide, a little busy slide, but helpful slide, which is slide 42. Yeah, this is how you would calculate a situation where the effective tax rate is less than 15%, then a top-up tax is determined. And IRR, income inclusion rule, imposes a top-up tax on the parent entity in respect of a low-taxed income of a constituent entity. So effective tax rate is determined as an excess of the agreed minimum tax over the effective tax rate as calculated on a jurisdiction wise. So this is how you will calculate the top-up tax, where the ETR is less than the agreed minimum tax rate. And how do you compute ETR, which is the effective tax rate? Let's go to next slide, please. Yeah, so this is how you would compute the ETR. I would rather urge you to just go through this particular slide. And how would you compute under tax payments? That is given in the next slide. The idea is to ensure that corporations do end up paying a 15% minimum tax, and anything less than 15% will be a subject matter of application of under tax payment rule, and therefore you would need to figure out the basis of computation. Again, only few handful of companies will get qualified under the globe thing, but suffice to say, some basic minimum level of general awareness would be helpful. Yeah. So, what are the recent developments? Very quickly, let's go through the same slide 48 onwards. Yeah, for those of you who are interested in Globe and Pillar 1, Pillar 2, I've done a little bit of critique analysis of what should have been there or what things, and these are still things which are work in progress. By no means this is a final draft. Yeah, first and foremost is whether India will resile on equalization levy. That is the first challenge, because the global digital tax deal only covers companies and considering the same, and considering that if this year India ends up collecting another 100% more than 2,000 crores, it's another 2,000 crores, then there's the temptation of withdrawing it, or it will be a calibrated withdrawal, we don't know, or it will be withdrawal in bits and pieces. But for the moment, the grand norm is that once the global minimum tax comes, you will have to withdraw. So would India give up on EL from 2023? That's the first challenge. Then what has recently has happened globally? Next slide, please. In Europe, the EU has given a directive to incorporate the model globe rules in the directive itself. Next slide, please. So after the publication of the model rules, the EC published its own legislative proposal for a EU directive to incorporate the model rules, right? Now, if incorporated, member states will apply the provisions of the directive with effect from 1st of January 2024, right? Now, on the US side, very recently, I mean, as recent as only a few days ago, the US senators have asked an explanation from the Treasury. Next slide, please. On whether the two-pillar solution which has been propounded, whether it affects the commitment of whether it affects the US businesses or it negatively impacts the US competitiveness. So they've asked the US Treasury to figure out all these things. You should remember that in the Trump administration, there were the US tax reforms carried out with regard to international businesses of US entity, and there were several ways and means of new ways of taxation which were propounded, and therefore the lawmakers in the United States have asked the US Treasury to highlight whether this actually affects derogatory in a derogatory manner, and therefore have sought clarifications uh, on such measures. Look at clause E. It says positions of DSTs collected if Pillar 1 is not implemented, whether such countries would be free to enact DSTs later. So this points out to India also. Then look at clause D. Detailed analysis with regard to US bilateral treaties, PV provisions would be modified and dispute resolution could be reached without any treaty approval process. Whether the US would enter into a multilateral convention if treaty actions will not be necessary to implement Pillar 1. What are the timelines to implement Pillar 1? So all these, every country wants to protect its tax base and tax revenue, and these are certain concerns which have been highlighted from a US side. So we've seen the US concerns, the EU directive, and before that the India's thought process with regard to EL. I think the clock has crossed my allotted time. So with this, I'll give a rest to my presentation. Happy to take questions if any. So much to cover in 2 hours. Pretty much everything under the sun on digital business taxation. This was what I could present, but by no means this is exhaustive. This is just a teaspoon out of the great ocean of world of taxation, which is now intertwined with digital economy. Over to the organizers, please.
Thank you so much. Over to you, sir, for vote of thanks.
Thank you very much, sir. Your great efforts, and because of all the speakers, we could conduct this 3-day, 12-hour international taxation seminar series with the help of the speakers like you. And on behalf of all the speakers, I thank you very much on behalf of the ICAI International Taxation Committee and also SIRC, Aseem Gupta sir. So if at all, because of the paucity of time, if you can share the details of your mail, our members, if they have any queries, they would definitely they would contact you. Please, I request you to please respond to their queries if any. Thank you, sir. So thank you very much, sir. I take this pride. Shelva, anything else is there? Shall I conclude by proposing vote of thanks?
So, sir, we have. Yes, sir, we can propose a
Hello?
vote of thanks. Sir. Yes, sir, we
Yes.
can take up vote of thanks, please.
Yeah, at the outset, I thank and congratulate each one of the members who have participated for all the 12 hours here, and that too in a very big number, hundreds of people, and this tax audit pressure. This shows the interest the members have and the commitment of the institute to reach out to the members both. So the commitment of the members is the cause for conducting such programs. I wholeheartedly thank on behalf of ICAI and also on behalf of SIRC all the delegates who have participated here. Please continue to support us in the same way, and this is made possible by the Committee on International Taxation of ICAI under the chairmanship of CA Pramod Jainji. In his absence here, I wholeheartedly thank him on behalf of the members as well as the SIRC. So also Nandakishore Hegdeji, the vice chairman who came on the inaugural day and gave the opening remarks on this some series on this program, national conference. And also I thank the chairman SIRC, K. Jalpati, for coining this program and joining hands with the ICAI International Taxation Committee to conduct this national conference of 3 days. I would be failing in my duty if I don't mention each one of the speakers here. First day, it was K. Sudarshan sir, who handled overview of international taxation. It was the curtain raiser for the whole program. And the second speaker on the first day was principles of interpretation of tax treaties, DTA, and overview of MLIs by Siddharth Banwant. And on the second day, day 2, there were three topics: NRI taxation, new residence provisions, return filing obligation, disclosure of overseas assets issues, and cautions by Jai Kumar Tejwani. I thank him in his absence, and also I thank Rajendra Prasad ji, who conducted inbound and outbound investment structuring and FEMA and international tax perspective. And in the absence of Mr. Arpit Jain, who had to have a topic on foreign tax credit credentials, foreign credit analysis. I thank CA Karthik Natarajan, who came in and filled the deficiency of his absence. And a special thanks to Karthik Natarajan sir, and also Karthik Mehta ji for conducting today's first session, and Aseem Chawala ji for conducting the second and concluding session for this national conference. So I wholeheartedly thank all the speakers. You are the real assets of the institute, and but for your passion and sacrifice, such programs definitely cannot be conducted. For the benefit of members, the speakers are not coming for remuneration, and they are coming with their heart and the passion to serve the alma mater. So with these words, I thank once again the SIRC committee, Mr. Selva especially for technical support, and all the back office staff of SIRC for supporting us, and also the coordinators at ICAI committee, International Taxation Committee. So with all this, thank you all for making this session, this conference, a wonderful session, and also a very successful session. And the members are definitely enriched after attending this program. So thank you one and all. Jai Hind, Jai ICAI. Thank you.
Thank you, sir.